minute think আমার
My foot had date to very
আমারও সেটার উপমে
হইল এটা বিষয়ে একটু মনে পড়ে ম্যাটার বা সেকেন্ড করে দিও তাতে তো মানে টিউসডে বা টিউসডে Make digital lordship. Back to mention item number 43 of the main list, my lord. Last item, my lord. But I have taken consent of the other side, my lord.
I am put a respondent, my
The
lord.
petitioner.
To make any fixed date.
Long
pending
a
matter,
hearing
my lord.
date, my lord, may be fixed, my lord. Tuesday or Thursday, if possible, my lord. My lord,
Sir,
in the second week of February, my lord, if possible.
43
43.
last
Last item.
hearing 10 and 12 is almost full, so it may be on 17 at best.
My lord.
17th of February.
My lord. Must
Will do.
oblige, my lord.
Wait for it.
Suppose Monday.
May it please your lordship. I beg to mention item 11 of today's list, your lordship. Here the respondents are deemed they have not entered appearance, your lordship. So the matter can be heard, but only thing, your lordship, today I have certain difficulty. I pray that matter may be adjourned today, next week or first week of February.
But in regards to your service, whether there is any order?
Yes,
that-
yes. Your lordship may see 26/5/25 order. There's an order of dishonorable court where the service has been deemed served, but still after, in May itself they have deemed served, but they still not entered appearance. So the matter can be heard. I think I'm praying for adjournment today, next week or first week of February, as per your lordship.
Otherwise, it was in an admission call.
Admission call.
Item number 11, you are saying.
11.
Do you want any fixed date here or
Fixed
first
date.
week of
Fixed date would be convenient also. Fixed date.
4th of February? That
Obliged. And the interim order may be continued.
interim was there.
Yes.
Interim
Still
becomes still later. Interim.
obliged, your lordship.
May I please your lordship, I beg to mention listing of RSA lordship. I have filed on 8/1/2026. Let the matter become on Tuesday, 27th, because Monday is a holiday.
In hearing
RSA,
or
second event.
no, in hearing column or
No, for listing of, for listing.
listing in where?
Motion.
That means hearing on that money.
Motion hearing. It will be fixed as motion hearing. Let it be on
Tuesday,
27th, lordship.
28. 28.
30th, lordship, because I will be out of station on 20th, 29th,
30.
30th. Master Bags.
May I please, lordship? Lordship, I beg to mention one CRP under Article 227 to be unlisted today as an unlisted matter.
Oh, sorry.
Lordship, with very urgency is there.
I have to, in fact, in second half, I may not write.
Then tomorrow, lordship.
Tomorrow is not.
Your Honor, lordship, actually huge amount is involved, lordship. That's why, Your Honor, it's very urgent. Now, interim order is
Not
of
possible tomorrow.
2024.
27th.
2024 order is there, interim order, Your Honor, that has not been decided till date, lordship. Now,
27th.
tomorrow, it's
Tomorrow
tomorrow.
may not be possible. Tomorrow is already there.
Two your lordship.
Because on 23rd, in fact, I'm leaving for Aizawl, so it may not be possible.
Tomorrow at two lordship.
Not possible. I cannot, may not be able to pass the order itself. So maybe on 27th at best.
Okay.
May it please your lordship, I beg to mention two I civil for listing in the orders column. One is for condonation and one is for early hearing. Be listed tomorrow or 27th.
Cool. 28. 28.
Lordship, I beg to mention another RSA for listing in the orders column. Notice was issued and TCR was also filed. Lordship, this
Maybe
also,
on 30. 30.
your lordship.
One pending RSA, my lord, from the year 2014, my lord. It was last listed 11/11/24, my lord.
In hearing column?
No, my lord, already, my lord, a delay, there is some 32 days delay, my lord. Substitution was done,
Till the delay is not confirmed.
not condoned, my lord.
What is substitution petition?
Yes, substitution already allowed, my lord.
Then why?
Subsequently, what is happened, they are not appearing, my lord, showing, my lord, different poses, my lord.
No, you are saying delay condonation means
Yeah, yes, my lord. It has to be first disposed of, my lord. Delay condonation petition, my lord.
once you are saying that substitution is already
It was
allowed.
1921/14. Yes, was.
No. Once you are saying that it is delay is
Yes,
is to be
32 days.
decided, again you are
Yes.
saying the substitution is already allowed.
During the pendency, legal hair expired of the respondent.
Ah.
We have substituted.
Ah.
Appeared, my lord. So
Ah.
matter has to come, my lord.
Delay is already condoned.
Not condoned, but during the
Then can-
pendency, notice was sent to the, my lord, notices were sent to the respondent, my lord, sole respondent. Subsequently, what has happened? The sole respondent expired. Substitution petition was filed. They have appeared, my lord.
But without condoning the delay, without admitting your appeal, the delay, your
In the
substitution is
condonation-
already allowed.
No, only condemnation petition, it has been allowed. Substitution. Before the condoning the delay,
Ah.
the substitution petition filed for the respondent, my lord, it has been allowed.
Anyway, it is delay condonation 14 or method. 28 of the
Oh, that's
May I please, your lordship? Your lordship, with the consent of the other side, I beg to mention item number 8, your lordship. Maybe pass over for the day, your lordship.
have you
Inform the other side.
understood
Please,
you
yeah,
for the
yeah.
petitioner?
Sign for-
Number 1 and 2.
Consent of the answer. After 2 weeks we'll do.
After 2 weeks.
It's done.
Interim may be continued.
Interim was day.
Interim.
Interim be continued.
Much obliged.
May it please your lordship. I beg to mention two matters for listing in order columns any date on after 26 lordship. 27, 28 or 29 any date. Lordship.
29.
Lordship obliged. And another prayer lordship item 49 of supply list. The matter is listed in hearing column. My learned friend is appearing for the petition appellant and I am for the respondent lordship. In this case, injunction was granted by the learned trial court in our favor. That order was stayed by this honorable high court. But after passing of this order, lordship, they entered the bricklane industry and they are now trying to operate the bricklane industry. In fact, we are the lessee of the bricklane industry, lordship. So may I pray for upgrading the matter and maybe taken
No,
at
you have
12?
filed one IA.
No, lordship. They have filed the order already. It was stayed, lordship, injunction order.
Ah.
So for final disposal, can it be, lordship, taken up at 12 p.m., lordship?
Upgrading
Your lordship
may not
may be rising at
upgrading may
1.
not be possible and hearing may not be possible today.
Lordship, in this case, what happened? Last order, it was reflected that matter may be listed for hearing, but not yet admitted, lordship. So it's a admission matter, lordship.
If simple admission order has to be passed, then it can be upgraded. Otherwise, hearing may
Admission matter, lordship. In fact, lordship may take
simple
the-
admission will do. Otherwise, no or any order can be. I am in a hurry today.
lordship.
Some
Lordship,
Maybe-
they may have some.
I am led by Mr. T.J. Mahanta in this case, Lordship. He has some difficulty today, Lordship, in upgradation, Lordship. He has some partner matters in another court.
In that
Today
case,
there is
lordship,
difficulty.
then if it is simple for admission, then it can be upgraded or not upgraded. I don't know whether it will reach or not, but at 2 at best it can be. But 2 will be
Lordship,
possible.
Lordship
There
may
is
be
some
not
difficulty
sitting
today,
today.
Lordship.
To
Next week, any date, Lordship?
Lordship is sitting at 2, lordship. After 1, this bench is not available. Ben, DB bench is there maybe.
No, no, no. No,
Lordship.
we will be here.
Then add to lordship at least some modification of the earlier order so that they may not disturb
No,
Lordship.
in that case,
At
we have to
lordship
be
for-
here the other side.
for admission hearing lordship.
It is not yet admitted, simple. I'm
Lordship,
just
my
saying that it is
properties are
simple
lying
admission,
in the
then it
brick.
can be admitted.
Lordship.
Otherwise, I don't know.
My properties are lying in the brick lane industry and
Okay, we're
they-
placing it on 28, going to 27. 27 itself.
27 lordship. Oblige, lordship.
Much
The
obliged.
request going.
Lordship, they are interim to be continued.
Interim was there. Who's interim? Yours.
Lordship.
27, one going to interim be continued.
Oblige, lordship.
Much obliged.
Yes,
Please, Your Lordship. Also, I make mention for motion, my lord, tomorrow.
not possible. Will
My-
be At best on 27.
My lord, my respectful submission, my lord. This matter is to be placed before Your Lordship by my senior. He is leaving station tomorrow evening.
More minute.
Tomorrow second half, my lord.
Not possible. At best on 27. 27. I'm listing it on 27.
My lord, if time permits, my lord.
27.
This will be listed tomorrow, my lord. If time
No,
permits,
no,
this will
it
take it up.
will be quicker.
Otherwise, it will go-
27.
It will roll over to 27th, my lord.
We'll list it on list, will be listed on 27.
Much.
May I please, Your Lordship? Lordship, with regard to item number 29 listed before court number 16, Your Lordship, for orders, can
No,
it be,
the-
Lordship, listed? tomorrow?
Just a second. We are, as per the notification, itu আপনার কিমান এই যে কাটা দিব দিছো আর্জেন্ট item number 29
29, Your Lordship, for tomorrow, Your Lordship.
আমার একটু লিস্ট আছে নি no no it's in that case you submit your mention memo, we will list it in tomorrow only.
Much obliged.
Item number 29 you
29,
said.
Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 26 of daily list. Lordship, my senior is suffering from some physical illness. Lordship, kindly adjourn the matter for 3 weeks as per the condition
26
of Lordship of daily list.
who is your senior
BK Das, Lordship.
DK
BK Das.
BK Das.
Yes, Lordship.
He is suffering from
Yes, Lordship. Physical illness.
Acha. You are Mr.
P. Medhi.
P. Medhi. But Mr. P. Medhi appearing on behalf of Mr. BK Das.
For 3 weeks, Lordship.
The big financial stating that Mr. and discount is in this. Let the matter be listed after 3 weeks. Then it
Mass obliged.
May I please, Your Lordship? I beg to mention for listing RSL.
in which stage?
29
Hearing
or 30, motion, Lordship. It has been filed on 3/10, Lordship, on October, Lordship.
October
Yes, Lordship. Still
29,
not
by
listed, Lordship.
29. RSA motion. মানে no 29. Okay, on 29.
Development.
Make pleasure, Lordship. Lordship, with the consent of the other side, I beg to mention item number 20, my lord. My lord, my senior is now out of station, so matter may be for 2 weeks, my lord. I'm the respondent number 1, my
So you have taken consent of the other
yes,
side
my lord.
because it is for hearing on the order 41 in anyway with the consent of the other side, consent for the respondent. And I join. Estimate accordingly after
2 weeks, my
2
lord.
weeks.
Yes.
List 2 weeks. Then it is. Was there any interim? Do you have any?
Oh, my
May I please, Your Lordship? I beg to mention item number 21. This matter will be taken up next week, my lord.
Here, the respondents, okay, it's
No.
not yet admitted, na? At the request made by the land. Yeah. Same matter. Then it is.
Lordship,
Lordship, I beg to mention for listing the matter for motion, Lordship, transfer matter for tomorrow, Lord.
No,
This 27, Lord, if possible. Obliged, Lordship.
transfer matter only,
Lordship,
transfer matter.
transfer matter.
May I please your lordship. Lordship, I'm praying for listing of this CRP lordship, civil revision petition in the orders column lordship.
29, right? 29, but 29.
Oblong.
May I please your lordship, I pray for listing as CRP for admission column on 27.
Which is not this by 30, 30.
May please your lordship, with the consent of the other side, I beg to mention item number 13 of today's case, lordship. And
1-3.
1-3, lordship. Lordship, matter will be listed on next week, lordship.
You're for the apple?
Appeal and lordship.
The respondent, lordship, in your first. Pardon. Yes, people. The apple. That is it. List accordingly. How many weeks later you want?
Lordship?
You want to fix it on after 2 weeks or
No, on next week, lordship.
next week?
Next.
After 1 week.
Yes, sir.
But we cannot maybe it won't be possible to give you date because it is already full.
Yes.
Till 12th of February, most probably it is full in fact.
Any day after 12, lord.
After 12th of February.
Yes.
Then second week of then
Yes.
list the matter accordingly. Second week of February as on effective. The second week of February by list.
Obliged.
May it please your lordship. May I pray for listing of an interest case, your lordship, in the orders column in any date in the second week of February, your lord.
11th of February.
Deeply obliged, your lordship.
May it please your lordship, it is a MSc matter. And the matter has not been listed for 6 months. So I humbly prayed for next week to mention
In
the
which column? In admission
Hearing.
case?
for
hearing.
hearing.
Hearing or data. 5th of February.
May I please lordship? Issue praying for listing on IA in MSc appeal lordship. Orders lordship. I'm delivering information, new documents. Lordship.
Second meeting. Second of February.
Okay, lordship.
May I please your lordship. Lordship, I beg to mention for listing of one I lordship. I is for condonation of delay lordship.
In MSc.
In preferring RERA appeal lordship.
RERA.
Matter will be listed on 30th lordship.
30. 30.
Much obliged lordship.
May it please your lordship. Your lordship, I beg to mention listing of 2 MFA. Ma'am, both
which
your
call?
lordship. Hearing stay.
Hearing stay. Now see up to 17 it is full. So maybe on 19th of February at best. 19th of February.
Much obliged.
May I please your lordship? Your lordship, I beg to mention item number 2, your lordship. Your lordship, the conducting council is suffering from chickenpox, your lordship. Your lordship, may kindly adjourn the matter
Malakar.
for Rabbi Malakar, your lordship. Your lordship, may kindly adjourn the matter for the day, your lordship.
Oh, they not there for 2 weeks. Let it be adjourned for 2 weeks.
Yeah.
At the request made by the matter is at the request made by at the request made by the your good name.
F. Shaheen.
Hard MS F. Shaheen, the land council appearing on behalf of Mr. B. Malak and this petition with and paid for an adjournment stating that Mr. Malak is suffering from chickenpox. Let the matter be listed after 2 weeks as an edit.
May I please your lordship. I beg to mention an item criminal revision petition for listing.
Criminal is not here. You make a mention before, I don't know, you see the code in your code.
May I please your lordship? Lordship, I beg to mention listing of a matter for orders.
What kind of order?
30.
What kind of matter?
Matter.
Matter P.
Yes, lordship.
In order call.
Yes, lordship. Last listed on 22, lordship.
22nd of this month.
No, lordship. 30th of January. 30th of January.
1-3.
30. 30th of January, lordship.
30th of January is yet to come.
Yes, lordship.
No, 30th, we are today, which date? Today is 22nd.
Yes, lordship. No, lordship. I'm telling to listing on 30th of January.
Oh, you're praying for to
30th
be
of
listed
January.
on 38th.
Yes, Lordship.
38th. Okay, 38th. Okay.
May I please, your lordship? Your lordship, with the consent from the other side, I beg to mention item number 7. As the conducting counsel, Mr. S.P. Roy, won't be able to attend the court today due to some personal difficulties. Matter may be taken up after 3 weeks, your lordship.
Who is not in a position to appear? SP Roy.
Mr. S.P. Roy.
Have you taken consent of the other
Yes,
side?
your lordship.
With the consent of the other side, the learned counsel appearing for the petitioner, please join it. Okay, it will be listed after 2 weeks.
3 weeks, your lordship.
3 weeks. 3 weeks.
Bless your lordship.
Wait, please, your lordship. Lordship, I beg to mention for listing a testamentary appeal for orders, lordship. Execution proceeding is going on, lordship, on 30th of January, lordship.
So matter has been listed in.
For orders
I
only,
don't know.
lordship.
Anyway, okay. That
Oblige, your lordship.
Yes. Oh, you're for the respondent.
I am for the respondent, 2 and 3, madam. Oh, 1 and 2, madam.
You're for 1 and 2.
Last occasion also probably, madam, they were absent, madam.
On the last occasion.
Actually, originally the petition was filed, madam. Now, by the order passed for converting it to a civil division petition, madam. Because no reply, when the judgment decree passed by the
I don't know.
district judge, madam.
Yes, but on 21/8/2025, one order was passed.
Madam. For
That is the
conversion.
last order.
Madam, last one.
And whereby and so they were also asked to file a amended cost atlas.
Cost madam. That mostly that has been complied,
been
that has been complied, madam.
That has been.
For that actual matter is listed for.
The office code dated 17th. 17th.
Well, earlier it was listed at WPC.
WPC, madam.
Amended cost atlas. Okay, it has already been done. Now they are not getting today. Hey, you are for respond number 1 and 2.
1 and 2, madam.
1 and our none appears to call for the petition. While Mr. done it assisted by that's it done it counsel for the respondent number 1 and 2. Comment yes. Respond number 2. The comment. The government council appearing for the state respondent. We're listing it after 2 weeks or 1 week.
Let
Let's
madam,
see
let.
what happens. One more from the office note. From the office note, it is 17/12. 17/12/2025. It is seen that the amended cost that has also been already furnished by the petitioner in person to order dated 12/12. In person to order dated 21/8. Is the matter accordingly after 2 weeks as donated.
It is your lordship. Lordship, I filed this CRP with a simple prayer that the title suit, it has been pending. It was filed in 2008, and in the month of November 2023, the plaintiff has already concluded his argument. Since 11/2023 till 2026, your lordship, adjournments are being sought by the defendants. So my simple prayer, and more than 3 adjournments have been allowed, almost 10 to 12. So my simple prayer is that your lordship may kindly direct the honorable court that on 26.
Have you annexed the order sheets also?
Yes. Since 2023, your lordship, at page number 50.
Page number.
Yes. Since 2020, 11/1/2023, I have annexed the orders till the last order. Your lordship may see at page number 56.
So then 11/1/2000, since 11/1/2023, matter has been fixed for argument.
Yes. And after that, your lordship may peruse page number 56.
You are the
Plaintiff.
defendant,
Plaintiff. Yes.
and defendants are paying for adjournment.
Yes. On page number 56, your lordship will see that I have already completed my arguments. That was on 9/11/23 itself.
9/11.
Yes, page number 56, your lordship. Two years have passed, your lordship. This is 26 now, and even on the last day, the court was not there for some reason. So it was next is fixed on 26th of February. So I'm paying 6th of February. But simple prayer is that no further adjournments be allowed by either parties, and expeditiously this matter may be closed.
You are Mr.
C. Gogoi, your lordship.
Part Mr. C. Gogoi, Defendant Counsel for the petition. It's an application that against the dated 11/9 passed by Tenancy Senior Division. Removal in TS 97 of 2022, whereby the learned court and granted further adjournment in favor of the defendant fixed the matter on 10/12/2020. On 10/12/2025. So
The court did not sit on that.
It is what is submitted by Mr. Gogoi that case was fixed for argument on 11/1/2023, and since then the matter has been fixed for argument. On you have completed your argument
On 9/11/23, page 56.
However, the plaintiff of the petitioner side has completed their argument on 9/11/2023, and the matter is now fixed for argument for the defendant side. But till that, the defendant is not proceeding with the argument, and there are several adjournments sought by the defendant which were allowed by the learned trial. Mr. Gogoi further submitted that on the last occasion, that is on 10/12/2025, the presiding officer was absent, and the matter is again posted on 26/6 for argument. Thus, it is seen and accordingly submitted that since from the year 2023, the matter is fixed for argument, but till that the defendant is not completed his their part of argument, and case and several adjournment has been made which were only allowed. Mr. Gogoi accordingly submitted that direction may be given to the learned civil judge senior division to expedite the matter to hear the argument on 26/2026 without granting any further adjournment. I don't know. Next, but hearing the submission made by learned counsel for the petition, so with this record and the annexures filed along with the petition, especially the order sheets used from the available order sheets. It is seen that the case was fixed on 24/2/2023 for order for argument by its order dated 11/1/2020. And since then, the matter is fixed for argument. Argument goes. It also reveals that on 9/11/2020, the plaintiff of the petition had already completed their part of it. And since then, the matter is fixed only for the argument of for the defendant of the respondent side. From the orders, it was reveals that on several occasions the adjournment was granted by the trial court below, and thus the case is pending for more than 3 years for at the stage of in view of this, the Learned Civil Justice Senior Division, Dibrugarh, is hereby directed to hear the matter on the next date of listing, that is on 26 without further adjournment, and will also make all endeavor to dispose of the matter within the observation the present remote instance.
Legitimate. Much of it.
I believe your lordship. Lordship, this is a transfer petition for transfer of the case, divorce case, from the Court of Honorable Principal Judge Family Court to District Judge Bongaigaon, on the ground that Family Court at Kamrup does not have the jurisdiction, your lordship, as per section 19, your lordship, of Hindu Marriage Act. The marriage was solemnized in Bongaigaon, and both the parties are resident of Bongaigaon, your lordship. And at the time of presentation of the petition, the wife is also staying at Bongaigaon. The husband filed the case at Guwahati, your lordship.
Why?
Just
is posted at Guwahati?
No, lordship. He is a businessman. He has a temporary address here. He chose to file in Guwahati just because to harass the wife to he has to come to Guwahati and come into a negotiation or settlement. That is the reason. As per section 19, it is clear that the husband's place of residence does not matter if the wife stays at the place.
So what is the stage at this stage?
She has just received the summons, your lord.
Appeared or not?
Not appeared.
Do you want any
The
further?
date is on 3rd of February, your lord.
Next date.
Next date is on 3rd of February, your lord. So at this stage, notice may go and the proceeding may be stayed, your lord, because first stage he has to come from Bongaigaon.
Case number 1518 of 2025 pending report. The Honorable the Learned Principal Judge Family Court number 2, Kamrup M at Guwahati. 2. The Court of Honorable District Judge or any other appropriate court at next issue notice to the respondent. Speed books and evidences. Next para, Mr. Mukherjee further submitted that the Learned Principal Judge Family Court, Kamrup at Kamrup, Guwahati, jurisdiction to take up the matter as the both the parties are the permanent resident of the district of Bongaigaon, and the marriage was only with a view to harass present petition. The case has been filed by respondent at before the principal judge family. Accordingly, he submitted that matter. The case may be stayed till the submission made by Mr. Mukherjee. They deferred proceeding case pending of state. Mr. Courts.
Madam.
This is a transfer petition, my lord. I prayed for transferring a proceeding, my lord, pending before the Honorable Court of Civil Judge Senior Division, Udalguri, to Civil Judge Senior Division, Mongoldoy. My lord, my humble submission is that, my lord, the plaintiff has filed a suit as money suit, my lord, relying upon an agreement, my lord. That agreement was executed at Mongoldoy, my lord. My lord, ordinarily the defendant residing at the jurisdiction of Durham District, my lord, that is jurisdiction of Civil Judge Senior Division, Mongoldoy, my lord, and his ordinary business are also running at Mongoldoy, my lord. My lord, there is no any cause of action arises within the territory of the Civil Judge Senior Division, Udalguri, my lord. And in other hand, my lord, the petitioner has not been feeling fairness in that court, my lord. Only one occasion he has sought for adjournment, my lord. On that occasion, he was imposed a fine of rupees 2,000, my lord. My lord, as such, my lord, for interest of justice, for fair trial, my lord, the matter may be transferred to the court where the actual jurisdiction is there, my lord. My lord, as per the provision of the CPC.
Putting a cost on your party.
Yes,
Is that you are not getting any. There is a apprehension that you will not get a fair justice.
Yes, my lord.
That cannot
Hey,
be.
all right, madam,
That
but
cannot be at a ground.
but
Now
limit.
see your case. I'm not in a position to file pass any.
My lord,
order of
kindly
stay.
see the agreement, my lord. Kindly see the
Whatever.
agreement, my
There
lord.
is some reasons why they have filed the case at Udalguri. Then is there
My lord, no any statement has been made in the plaint, my lord. How the jurisdiction of Udalguri court comes, it has not been reflected, my lord.
both the petitioner and the respondent, they are the resident of Mongoldoy, Durham.
My lord, the plaintiff is residing within the territory of Udalguri, my lord. The defendant resides Durham district, in the Durham district, my lord. Plaintiff resides.
You are the
I am the defendant.
petitioner.
I am the defendant,
Yes.
petitioner. My lord,
Maybe
the whole transaction, my lord.
Petition to pass any order, we issuing notice.
My lord, can you
And
stay the
that
proceeding,
your
my lord?
ground, you have submitted that the imposing of cost. Is also
My lord, that is different, my lord. That is regarding only fairness, my lord. But as per section 24(5), my lord, it is specifically stated, my lord,
Okay,
that
we will pass the, we issue notice on.
my lord, kindly see the provision of 24(5), my lord.
No, yes, I know. Heart, Mr. Dilani. This is a petition, the section 24 CPC for transfer of money suit number 10 of 2024, pending before the Granite Civil Judge Senior Division to the Court of Granite Civil Judge Senior Division Durham. Issue notice to the respondent to speak first. Otherwise, you have annexed the agreement and all, etc. here or no?
All document I have annexed, my lord.
I have not seen why.
Plain, my lord, agreement is at page, my lord, 55.
Agreement is at page
55, my lord.
No, otherwise we can call for the scan copy. That's why I'm just asking.
Yes, my lord. At page 55.
Agreement is at page 55.
55. On the top, my lord, it has written, my lord.
No, whatever it is.
Yes, my lord.
Then we are not calling for the case record. The simply you issue.
My lord, other documents I have not annexed.
The case at present.
Other documents I have not annexed, my lord. Only the plain, the written statement, and the agreement I have annexed.
Maybe sufficient to dispose of the matter. Otherwise, we have to call for the case record.
Yes, Lord.
Do you want that case record be called for?
My lord,
Scan
I think
copy may be called for.
it's necessary, my lord.
Scan copy of the case record. List the matter and which date you have fixed?
At the stage of PWs, my lord, evidence is going on, my lord.
Stage of PW.
Yes, my lord.
Okay, anyway. When it is listed, next date of list.
So tomorrow, my lord.
Tomorrow.
Yes,
That may not be possible. Do you want any fixed date here?
My lord, fix a date, my lord. My lord, may I pray, my lord, till then, my lord, only proceeding will stay, my lord.
We're listing it on 11 February.
11 February. My lord, actually, otherwise also, my lord, it's a commercial suit, my lord, that the Honorable Court has trying as money suit, my lord.
The transaction was commercial transaction.
Yes, my lord. Contractual work, my lord.
Then why don't you, file a petition for regarding the jurisdictional prayer or as a preliminary issue, you can file one petition.
Yes, my
It
lord,
can be
there,
disposed of as a preliminary issue. If it is not supposed, then it may be transferred to commercial.
yes, my lord, there they have not filed it, so my lord, that is not, I am taking primary
No,
as primary
your
ground.
side you can file
Yes,
regarding that, raising that issue. That may be considered as a preliminary
Yes.
issue. That may be-
Oblige the lordship.
The lodgable this revision petition is filed against an order, my lord, rejecting the petition, objection petition of the petitioners herein, who are the judgment debtors and defendants, your lordship, defendants, your lordship. The what
Your
happened, my lord?
petitioner are the
Defendants, judgment debtors.
Judgment debtor.
Yes, my lord. And what happened, my lord, in the during pendency of the title suit, your lordship, there was a out of
No,
court
you are
settlement.
the defendant, judgment debtor means your the counterclaim was there.
No counter.
Oh, judgment debtor.
Yeah, already
Acha, sorry.
already agreed, my lord.
Yes.
Already agreed. And my lord, what happened, my lord, during the pendency of the title suit was for right title interest and recovery of possession and cancellation of the mutation record. And during pendency of the title suit, your lordship, there was a village mail or bichar out of the court, and in that mail, it was decided that the defendants here will leave some portion of the land to the plaintiffs, and accordingly, it is settled that the plaintiffs will withdraw the case. And what happened? The defendants did not pursue the suit thereafter, and decree passed, and they are not aware about the decree. Next, after passing of the decree in the year 2016, decree was passed in 2015 in TS 19 of 10, and in 2016 they had a title execution case behind the back of the petitioners herein, and in that title execution case, after proceeding for some length, the decree holder did not pursue the title execution, and it is, my lord, dismissed for default on 17/7/2018. That was also without the knowledge of the defendants, petitioners hearing. Thereafter, after 4 years, in the year 2022, they again filed a title execution case, and in this case, in violation of the provision of Order 21/22, without issuing any notice, because it is after about 7 years, without issuing any notice, the title execution proceeded. And only on the date of the when the Nazir went to the place for delivering the possession, taking the possession, they came no, and they petitioners came to the execution court and filed an objection petition that we have not received any notice, and that also admitted that no notice is issued. That is page number 85, your lordship, of the impugned judgment. Impugned order of the executing court. The order starts from 81, your lordship. That petition was under section 47 of the CPC. The lordship, page number 85, may I read, ma'am? Page number 85, second paragraph, your lordship. Further, the petitioners pleaded that the plaintiff decree holder filed execution case 15/16, which was dismissed. And thereafter, plaintiff decree holder instituted a second execution application so and so without obtaining permission from the concerned authority. Perusal of the case record of the title execution 15/16, the first execution case, lordship, shows that the application for execution was filed on 11/8/2016. The record also reveals that as the application for execution was filed within 2 years of the date of judgment, and decree notice was not issued to the judgment debtors, defendants. Thereafter, the decree holders had taken up a step for precept, and the case was fixed for report so and so dates, lordship. Next page 86, but the decree holders remained absent on the 4 subsequent dates so and so, and the title execution case 56 was dismissed for default on 17/7/18. Thereafter, on 24/8/22, it is after 4 years of the dismissal, subsequent application for execution was filed by the decree holders, which was registered at title execution 2/22. So admittedly, it is after 7 years of the decree passed. So it is hit by Order 21 Rule 22. That is, if it is execution is filed after 2 years, the notice must be issued. So record also transpired that the execution, if so and so no issue of or matter was heard or finally decided by the executing court and the application for execution was dismissed for default. Therefore, principle of res judicata proved in explanation so and so not applicable. It is also held by Honorable Supreme Court so and so that an execution proceeding, however dismissed for default, does not bar fresh petition, though by time of dismissal it had been insisted one or more grounds. Also, it is evident from the case record that the subsequent application for execution filed in the year 22, within the period of limitation, the learned executive held that it is since it is within 12 years, so it is maintainable. From the date of the judgment decree and enumerated Article 136. Further, the petitioner pleaded that the execution proceeding is not maintainable. Want of notice of 2122 order 21 rule 22 of the CPC. Perusal of the case record so and so shows that no notice was issued to the petitioners and it was directed to take step for precept and execution. But petitioners pleaded that they come to know about the decree when Nazir went to the truth land for execution. Accordingly, they appeared and filed the instant petition dismiss of execution. The purpose of notice under 2122 to show cause against the execution by filing the instant petition. The petitioners have already shown cause against the execution. So my objection petition is held that it is complied with the order 21 rule 22. But my lord, it is a mandatory provision, my lord. At this stage, my lord, I pray for a notice, my lord, until returnable date the execution proceeding may state, my lord.
No, court rightly held this one. Now see, the intention or cause of issuing the notice, behind the intention of the issuing notice under 22, order 21 or 22, is that you should be informed.
Yes.
If the order of execution is beyond 2 years of
beyond 2 years, yes.
But at this stage, you have come to know and you have already appeared, so you will get ample opportunity to show cause as to why this.
It is at the stage, the final stage, right? The delivery stage, my lord. The final stage of the execution petition. When the Nazir went to the for delivering the position
Now
from me.
it shows cause. That's what the court observed. Last question you see.
Yes, my lord, but
show cause against the execution by filing this petition. The petition has already shown cause.
That is
against.
That is right, my lord. But as per provision of the law, the mandatory provision.
Mandatory provision is definitely, I can understand, it is
Yes.
required.
Yes.
But without behind the back, you cannot execute the
Yes.
case. That is understood.
Yes.
Notice is required. Now the court observed that already you have appeared.
Correct,
And though it was show cause was not notice was not issued to you, show cause notice,
Yes.
but you have already appeared, coming to know about the execution, and your show cause reply is already there.
But
that is the case. So what is the case now?
Oh, whether the objection at this final.
Now you can file your objection.
Yes, my lord. But the
File your objection.
yeah, but
If there is any objectionable ground
yes,
to file your objection under 47, 97 or 100, whatever,
yes,
you can file your objection.
that will sufficient time may be allowed, my lord, for the contesting the execution petition, my lord. That may be allowing the directing
So
the.
this is the miscase is disposed of. But
Miscase-
title execution is still there.
It's still there, still there.
So you can appear in the title execution case and your show cause reply can be accepted by the court.
Yes.
Now this is the observation of the court that you have already appeared.
Yes, ma'am.
So no need of again issuing notice.
Yes, my lord. My
So
lord,
it is already
direct-
disposed of. So now you want that your objection should be recorded
Yes, my lord.
in the title execution.
Yes, my lord. So, my lord, maybe dispose of directing the execution court, giving sufficient opportunity for my lord.
Filing your objection.
Yes, my lord.
So what is the present? What is the
Or may your lordship may
case
issue
number
notice.
of the present title execution?
My lord,
Present title execution case number is
case number is 2 of 22. Yeah.
the present one.
Present one, 2 of 22. Or your lordship may issue notice, your lord. Okay.
Mr. M.J. Kadir. It's an application under Article 227 of Constitution, Procedural Section 151 CPC, against the impugned order dated 21/11, passed by learned civil judge, Junior Division, Nagaon, in title execution number 2 of 2022, whereby the petition filed under Section 47 of CPC in title execution was dismissed. Your petition was under 47.
Yes.
But under the 47 was registered as a miscase.
In a miscase, sir.
So and so. Next, it is for the subject Mr. Khalid, that initially a title suit number 19 of 10 was filed by the respondent, respondent plaintiff, but during the pendency of the safe case, as per decision of May, the plaintiff of the decree holder agreed to withdraw the suit, and the both the parties were also agreed with the decision of the May. And thereafter, the plaintiff decree holder also withdraw the title suit with assurance that they would withdraw the suit, and after 1 week, it was also informed to the present petitioner that case has already been withdrawn. But thereafter, behind the back of the present petitioner of the defendant, the plaintiff side had filed a title execution.
15 of 2016 was passed.
Case number 15. Of the, that 15 of the 16, and the 15 which was filed on 11/8/2016, and this was within the period of 2 years from the date of judgment and decree, passed in title suit number 19 of the 2000. However, the said execution proceeding was dismissed by the court on 17/7/2018 to default on 4 of the 5 consecutive dates due to default of the plaintiff decree holder on 4 of the 5 occasions. But after the disposal of said title execution 15 of 2016, another title execution was filed. The present title execution was filed on when it was filed?
On 24/8/22.
24/8/22, which was numbered as title execution 2 of 2022. Behind the back of the present petition, and though it was filed after how many years? It was
After 7 years, my lord.
after 7 years, but no notice was issued, which was required under Order 21, Rule 22 of CPC. But the present petitioner of the judgment debtor came to know about the said proceeding only when the Nazir went in the suit premises for delivery petition. Thereafter, the petitioner immediately came before the learned civil judge junior division with a petition under section 47 for dismissal of the said title execution, which violated the provision of Order 21, Rule 22 CPC. But the learned trial court below did not consider this fact and had dismissed the petition filed by the present petition under 47 CPC, which was registered as MJ case number 170 of 2022. hide its order dated 21/11. Next part, submitted by Mr. Kat that they said that execution is not maintainable because of for want of the notice which was mandatorily required to be issued to the present petitioner of the judgment data in under the provision of Order 22, Rule 20, Order 21, Rule 22 CPC. Next. During the submission made by learned counsel for the petition and the order which has been annexed along with the petition dated 21/11/2025 in MJ case number 170 of 2010 in connection with title execution and DS 19 of 2010. The order seen that the learned trial court below had rightly observed that the purpose of issuing notice under Order 21 Rule 22 has already been is can 22 is 22 may not be complied with, but no, last time. Order is to show cause against the execution, but coming to know about the proceeding as the petitioners have already appeared and show cause to the in the said proceeding, the very purpose of issuing notice has already been served, and in view of this and with the, and with the said observation, the case was dismissed, which was filed under section 47 CPC. However, it seemed that said case was dismissed, wherein the present petitioner has shown the causes only for non-issuing of notice under Order 21, Rule 22 CPC. But this court is of opinion that an opportunity may be given to the present petitioner to show cause, to file their show cause reply as to why the decree passed in that TS number 19 of 2010 is not executable, or may be given an opportunity to raise objection to that. In view of this, the learned trial court bill is hereby directed to hear the in view of this, the petitioner is at liberty to file a fresh application under 47 or any other provision to that aspect against the execution of decree passed in TS number 19 10, and in that event the learned trial court below is hereby directed to hear both the parties and to dispose of the matter. Now, what is the stage at this stage?
Well, at this stage,
after your dismissal of your petition,
then again the Nazir was issued for report of the Nazir.
Till then, and for further, the petitioner is hereby directed to file the petition in the nature as stated above. in the nature as stated above, within 15 days will do.
15 days.
Within 15 days from the date of order today. And till date, the execution process under title execution 2 of it will stay.
My lord, till disposal of my petition. Till disposal of my petition.
But if it is delayed, then again it
Now we'll file as per direction of the Honorable Court within 15 days.
and will till disposal of void. And will be stayed till disposal of. But you have to file within 1 month. How can we say?
Within 15 days, within 15 days we'll file. Otherwise, I will submit the order to the Honorable Execution Court along with the application.
It cannot be a never-ending process. No, that's why I'm asking.
Within 10 days, we can also file them.
That is, we have given you 15 days.
Yes.
And the matter may be disposed of within maybe within 1 month. He can dispose of, the court can dispose of. You can file your petition within 15 days and court may dispose of the matter within 1 month. After hearing you. Otherwise, it will be never ending.
Yes,
You will,
yes.
if you seek for adjournment and all, then it will again create problem, na?
Yes.
For execution.
Regarding adjournment, a direction may be given. No adjournment.
Within 15 days, we examine last line to within 15 days from the date of order, and the learned trial court below will also dispose of the matter, preferably within 1 month after hearing. We given an opportunity to both the parties.
Obviously.
With the above observation, the present CRP is disposed of at the process.
Till then, it is stayed. Till the
It is disposed of.
Till the disposal, my lord, the execution is stayed.
It is stayed.
Probably.
Hearing was.
Please. Lordship, there is subsequent second application, Lordship. Lordship,
we have what we have received anything? CD receipt. Okay.
Lordship, total 11 sections were incorporated. Lordship.
Lordship,
Lordship, and today length of detention, Lordship, it is 59 days, Lordship. And all offences are 60 days offence, Lordship.
56 days, right?
I have counted it as a 59 days, Lord.
25/11.
23/11, he was, after that, he was taken, no, 2 days custody, 2 days. 23/11, he was taken into custody, then
then 58.
on 25th, he was sent back to judicial custody.
Case of 60 days of.
60 days.
The offense is there.
Where is the earlier or
Lordship, it is on page 31, Lordship.
31?
Lordship, in this case, Lordship, earlier the detention was, plea was taken. Lordship, regarding the more than 24 hours detention was, plea was taken. In this case, Lordship.
That was the main plea, I think, na?
Yeah.
Anyway, it was disposed of.
Yes. Now, as per 23, if 23/11,
23, then 59 days.
59 days.
No, I'm asking whether 60 days offense is.
Lordship, because others are 319, 318, 318/4, 336. All are not.
60 days.
Otherwise, lot of materials are there.
Yes, sir, they are
That's a-
changing the number plate and all. These are fact,
Yes,
na?
that was the case.
On the length of detention, maybe lot.
Only length. That much.
But they have defense DRDO lordship, and witnesses are also there who has been seated. There one witness lordship, he has stated that they asked him in their dress and took to their office, fake office lordship. And the pistol is also their lordship. He was asked, he is a builder lordship. In their they have stated that it is their plot of land, but which is not their lordship because they don't have any document. But still, they stated them to pay him lordship first, to pay to construct the building with his money lordship. And they have also, he has also taken 5 lakhs rupees lordship. Check is also with that person lordship. With this kind of cheating is there lordship.
But
Otherwise,
the within 1 day, most probably charge sheet is not possible.
not.
What is the stage? Is there any note from the IO here?
It is not specifically stated that, Lordship, but investigation is going on what other persons are they are involving. Still going on.
Stringent condition may be imposed, Lordship, and purity may be imposed.
You're Mr. Mehdi, isn't it?
D may be, Lordship.
But the Bormon name is there.
Lordship, by mistake that might be, but I have nothing.
Otherwise, you are the counsel.
Yes.
Had Mr. Mehdi, the learned counsel for the petition. And also had Mr. K.K. Das, the learned additional PP, everyone. In applicable, this is an application section in connection with swears. CD receipt, bill receipt. Next part. It is submitted by Mr. Mehdi that present petitioner got arrested in connection with this case on 23/11/2025, and till date he is in custody for 59 days. His earlier bail application was rejected on 15/12/2025. His present bail application may be considered only on the length of detention he has already done. The petitioner is a permanent resident at this point and will abide by all terms and conditions if he is allowed. Next, Mr. Das Tirane additional PP submitted in this regard. That there are sufficient implementing materials against present petition. However, he submitted that the investigation is still going on and the possibility of filing the charge sheet within 1 or 2 days may not be possible or next, considering the submission made by that without going detailed into the merit of the case, only considering the length of detention and again. Five condition. 50,000 with considered. Condition silent.
Deeply obliged.
Lordship, CD not able.
$19 not available.
CD not.
This is also a case earlier rejected.
Yes, ma'am.
Then to CD will be required. So now till now, how many days you are in custody? Oh, it's a AB. Sorry, ABC. You are Mr. Burman?
Yes, D. Burman.
Had Mr. D. Burman done it also for the petition. Also had Mr. K.K. Das done it. City not yes, when it
Second week.
Second week of February. It did.
No, the first week of February.
Sorry, first.
No.
Try to get the seat.
Not the blood.
Deeply
Or
obliged.
CD.
May I please, Lordship?
Yes.
It's a transfer petition, Lordship. I am the wife, Lordship, and the husband has filed an application for seeking divorce, Lordship. He filed that application in the district of Dibrugarh, and I am residing at Golaghat, Lordship.
It is filed in district of Dibrugarh.
Dibrugarh, and I am residing at Golaghat. And as per section 19, Lordship, the provision is that where the marriage has been solemnized and the wife where she is presently residing.
Marriage was as Golaghat.
Marriage was solemnized at Golaghat, and the wife is also residing at Golaghat, and which is apparent from the address given in the suit also itself, page 13. Page 13, the name of the petitioner, residing at Dergaon, so and so, Golaghat. She is residing at Golaghat, and another thing is the inconvenience, Lordship. The distance between Dibrugarh to Golaghat is about 190 kilometers, and the wife is not, the petitioner is not, has no income, Lordship, and she is also a minor's daughter, Lordship. Therefore, I am praying for transferring this case to Golaghat. And one more thing is that the wife had filed an application under the Domestic Violence Act and against the husband, and husband had contested the case at Golaghat itself. Earlier, I have made specific statement, Lordship, that he has filed, he has contested earlier case at Golaghat at page 13, paragraph 13 of page 6. He is working in APDCL as per my instruction, and I think it may not be inconvenient for him if the suit is transferred to Golaghat.
Otherwise, he is the resident of Dibrugarh.
He is a resident.
Yes.
And I am for the husband, my lord. Now, Lordship may kindly turn to page 14, my lord. The marriage was solemnized, my lord, at Duliajan, my lord, to Dibrugarh. Page 14, my lord, paragraph. Paragraph 3, my lord, page 14. And my lord, apart from that, my lord, Lordship may kindly, page 18, I filed a case for restitution of my conjugal rights, my lord, which was passed in my favor, my lord. That is at page 18. My lord, page 18, my lord, the page paragraph 15, my lord, which was, my lord, I have tried everything, my lord, to, my lord, save my, the marital dispute, my lord, between me and my wife, my lord, but it has failed, my lord. So, my lord, maintenance case was filed at Golaghat, I admit, my lord, but, my lord, when I went there, my lord, leaving my ailing mother, my lord. Now, my lord, I have filed a restitution of conjugal rights, my lord. I have tried to bring her back, my lord. She didn't came, my lord.
Well,
So-
your restitution of conjugal rights case has already been disposed of.
The page 18, my lord, paragraph 15.
No, it is already been
This disposed of in my favor. And
thereafter only you filed the divorce.
Lordship. And my lord, one more thing, my lord. I am ready for a settlement also for to pay her one time, my lord, amount, my lord, settlement amount. So that, my lord, because I have filed restitution of conjugal rights in my favor, but she didn't came back. So, my lord, if lord, he may take instruction, my lord, whether, my lord, I am ready to pay, my lord, as my instruction now 5 lakhs, my lord.
That I don't know, but as per the paragraph 3 and 14, marriage was solemnized at Duliajan, that means within the jurisdiction of Dibrugarh.
But
Now, yes, the question is that he already filed a restitution of conjugal rights also, the degree also there in his paper, but that was not shorter because it is a paper degree. So, but now he is still ready for a one-time settlement. Do you have any?
Even if that is done, Lordship, that is to be done, the case is to be transferred.
When she is not
because this honorable court cannot pass a mutual decree.
No, we are not passing it. We are just
Because for that period, for that also, both the parties have to file application before.
We are not passing any mutual decree. I'm saying that in that case, suppose there may not be any problem. I mean, may not transfer the case. You can dispose of the matter in one-time settlement. If your party is,
I will take instruction.
In that case, you take instruction.
Lordship.
Because again, troublesome, the record will come from here
Okay,
if the order is passed.
Lordship.
So you just take the instruction. If any
Fixed,
settlement
on the
is there,
next week matter is fixed. I will take that instruction.
you take an instruction next week. 29 may not be possible for you to take instruction in that. Let it be on thereafter, in the month of February first week.
First week.
It will, 4th of February will do. Card till it. 4th of February, card Mr.
D. Chaudhary.
D. Chaudhary, the learned counsel for the petition. And also card Mr. S.M. Abdul for the learned counsel response. Time of making submission by learned counsel is submitted by Mr. Abdul that there may be probability of certificate of the divorce. Hence, wait for some sequence of according to in that regard, Mr. Chaudhary submitted that he may take the instruction petition. In view of this, let the matter be listed on 11%. Court of
Oblige, Your Lord.
May it please your worship.
Yes. So, what is the position now here?
My lord,
Notice you have not taken steps.
we have taken step on the previous date. Notice was deemed to be served, lordship.
Deemed to be served?
Yes, lordship. My lord, lordship may kindly see the service report, lordship. Notice was received by the wife of the respondent, lordship, sole respondent. Flag Y is the service report. lordship.
Right? Why?
Yes, lordship.
Like why actually?
(27:10), the previous order may also kindly be seen. Observation is there.
What like kind of case this is?
Lordship, a transfer case, the respondent has filed a petition under Section 7 of the Guardian and Wards Act before the district judge Kokrajhar, lordship. And I am seeking transfer of the petition to Bongaigaon, 30 kilometers away, because I am residing at Kokrajhar, Bongaigaon, and there is a dispute between the respondent and the petitioners. Petitioner number 1 is the wife of the respondent, and petitioner number 2 and 3 are the parents of the petitioner number 1, lordship. Earlier, the petitioner got married. From that side, he got 2 sons. After the death of her earlier husband, she married again the petitioner, lordship. Respondent. But the respondent did not like the stepson's, lordship. Eventually, the respondent killed one of his stepsons, lordship. Thereafter, the petitioner number 1 divorced the respondent and filed FIR before the concerned police station. The investigation was completed, charge sheet was submitted. Now that case is pending. The evidence last stage, lordship. Now evidence is for IO, lordship, on 16/3. The case is fixed on 16/3. In the meantime, the respondent has filed this application, lordship, case 40. 40 is the notice and 41 is the petition, seeking appointment of guardian
For?
Of minor child, lordship. Minor son.
Minor son, that is 2 and 3.
No, lordship.
No,
2 and 3 are the parents of the petitioner number 1. Minor son of the petitioner number 1. The respondent is seeking guardianship of the minor son of the petitioner number 1, Lordship. Lordship may kindly see page 41 is the petition. And during the investigation period of the criminal case, the respondent was continuously threatening the petitioners, all the petitioners, that they will take revenge because he has been sent to the jail. And
Who is Jana? This minor is the son of whom?
Minor is the word for who is the guardian is seeking by the respondent. It is the son, both the respondent and the petitioner, petitioner number 1.
Now that son is staying with your
Mother, the petitioner number 1. She is denying because she has because the respondent has already killed one of his son, Lordship. Already killed. For that FIR is filed, Lordship is in the.
But yes, the question is that now why you suppress this the transfer of the case?
Because the respondent is continuously threatening the petitioners. It is the Kokrajhar jail is in the vicinity of the respondent, Lordship. They have the apprehension. If they appear there, they may attack, Lordship, the petitioner's, Lordship. Therefore, she is seeking transfer of the guardian of that petition to Bongaigaon. And
she is the resident of Bongaigaon.
Yes, Lordship. And distance is only 30 kilometers. The respondent can easily travel 30 kilometers.
Yeah, but your this whatever your second marriage or third marriage, but the marriage etc. were solemnized or not yet? There is no such.
No, marriage was solemnized, Lordship.
Where?
Lordship, 2019. 2019 marriage was solemnized. Thereafter, the son was born, Lordship, whom the respondent is seeking.
And which Kaji office marriage was solemnized in the under Kokrajhar district or Bongaigaon?
Actually, they were residing in different places. But so the marriage was solemnized in Bongaigaon, Lordship.
Not supposed to hear your petition may be admitted. Mr. M.I. Hussain, the learned counsel petition. The petition is an application. This is the petition under section 24. 54/120 or 151 CPC. Frame for transfer of Miss bracket G, capital G, of case number 4 of the 2024, section 7 of guardian and board pending before the Court of Learned District Judge Kokrajhar to the Court of Learned District Judge Bongaigaon. And from the office note, as well as from the order passed by this court on 27/10/2020, it is seen that the notice was duly served on the respondent, but he has not entered into evidence. In view of this, the petition is present petition is admitted for hearing. Is the matter accordingly for hearing on first week of February 2020, presented by the PST. Interim order shall continue. Just admitting.
My lord, in this matter, my lord, records will be required, my lord. 2 records. Records will have to be compromised. The scanned copies, my lord, of title suit, my lord, 187 of 08 and title execution 44 of 18.
44 of
18.
both will be required.
Yes.
I heard Mr. Esther done it. Also heard Mr. M done it. Appearing for respondent number. You are appearing for SMO 3, 4, 5, 6, 5, 5, 6, 5, 6. Next part, it is submitted by Mr. Das that for mission hearing of the petition to records of PS, records of PS 187 of it, and title execution of 4 of it. It will be paid for the This is scan copy will be required. Is
Yes,
that
your
the
lordship wishes.
dispose of matter? or
Dispose of matter.
Dispose
Dispose
of
of
matter.
matter.
In view of this, let the TCR of PS Swens application of Swens raised you will do it in the after 4 weeks we will be there all 3 weeks.
Next month, my lord. After receipt of the LCM, my lord.
We text it directed to list the matter immediately on receipt of the TCR. Was there any entry?
No.
And
Dispose of matter, my lord. Highly hope.
The respondent is not there, Milord. The adjourn the matter, Milord.
Oh. But you're Mr. Kaim.
Yes, ma'am.
Mr. D. Petition. One has requested a respondent side. Let the matter be according to the state. After 3 weeks, after 3 weeks, as an date you by this. Was there any entry?
Yes, Milord.
It will be continued till next year.
Obviously.
Punto. It's a criminal petition.
Criminal petition due to administrative order is there,
Ah,
lordship,
yes,
1 night.
yes, I have-
Especially assigned lordship. That is lordship.
So now, what is the stage of the case? I mean,
Appearance stage, lordship. And there is stay order, lordship. Last occasion it was not continued because that court did not take the matter, lordship, on 12/11, lordship.
12, 11.
12/11, last order did not take up, lordship, due to administrative order, lordship.
Acha.
Otherwise, stay is supporting.
One stay is operating.
Operating, lordship.
But now the question is that now see, those days operate. Have you taken steps for the
Step they appear, lordship. Name is reflected in the cause list also, lordship. Is for admission, lordship.
They've already appeared.
Appear, lordship.
I mean, the service is already complete.
Complete. They appeared earlier occasion also, lordship. Name is reflected in the cross list.
Ah, yes. But remain unrepresented or S. Goswami was appearing.
Appearing, lord.
The whole state is number 2.
But state actually it is
Limited
formal party, Lord.
Formal party, limited rule, lordship. Defamation case, on the basis of FIR, lordship, police submitted report and cognizance was taken. That is the issue.
In the report, it is clearly stated that this is a non-cog offense. Lord.
Non-cog offense.
Non-cog offense.
In our case is that, lordship, defamation cannot be initiated on the basis of report, lordship.
We are formal party, Lord.
They are formal party. It should be by aggrieved person and there should be complaint before the magistrate. And bar under.
But by name, you have made a party of officer in charge. Is you are representing going to represent 2, 3 also, no?
2 and 3 both.
Two,
Formal.
you can
Formal.
represent 20 because by name it is not.
Because their name is not.
Heard Mr. M.K. Hussain, the learned counsel for the petition. Also heard Mr. K.K. Thasil, appearing on the state respondent number. It refers that the name of Mr. S. Musaki is reflected in the court is appearing for the respondent number 1, but no no one has represented me. And no one has represented as phone number. The scan copy have already received. Scan copy of the TCR has already been received. Let the matter be listed after 2 weeks as an date by the registry. And further, the stay granted to the present petitioner. No, interim order granted to the petitioner shall continue till next.
Lordship, in one case, I want to one thing, Lordship, in item number 19. No, I was called for CD, Lordship, but I have just few minutes ago, Lordship, I have received, charge sheet has been submitted, Lord. On the next date or what to do, Lordship?
I don't know if you can inform the
Lordship. I have received information few
then
minutes,
it can be disposed of today itself.
Lordship.
But I don't know whether the other side is available today. No, I mean, he
I
was
will
there.
call
but
them, Lordship, then. If in the record there is number, his number is there, then I will have to call.
Try.
I will try then. Lordship.
You can try maybe at 2 p.m.
No.
If it is already charged, the matter may be disposed.
No.
And if it is not available, suppose in any case, then obviously into that. Yes, you have appeared already, na? For 1.
I am for 1 and 2, Lordship, claimant.
For 1 and 2. For 1 and 2. And that means you are for claimant.
Claimant, yes, Lordship, 1 and 2 for claimant.
And you are for? You are for? 3.
3 and 4.
So already completed?
No, Lordship, owner and driver are left. Lordship. 4, 5, 6, 7. Lordship, there are 2 vehicles. The owner and driver of both the vehicle are will be completed, Lordship.
The tribunal has already held 50-50, Lordship, where both the insurance are liable for 50%. Each.
Lordship.
It says Asarji's company is not liable, na?
Lordship, Lordship, as per the ocular evidence, the claimant have themselves said it, that our vehicle is not responsible. In the charge sheet is against the national insurance. And the tribunal has given no. Insurance আপনি বাকি 50 পয়সা নেই তো এক এক করে ডিফারেন্স প্রাইস এটা না পালে হয়
বলে নি
মাত্র মোটে দিলে আমি অ্যাডমিট করে দিছি আমি তো বলছি
1, 2, 3 and already appeared. 4 and 5. You issue
4, 5, 6, 7.
4, 5,
6, 7. Owner and driver of both the
vehicles.
But may I pray, Lordship, let
4,
the
5,
matter,
6, 7.
let the matter be admitted and my friend may be directed to pay 50%, Lordship. 50% out of the 50%.
Your stay petition is also there.
Lordship, my stay petition is also there, Lordship. Lordship,
but your part you have already paid.
Yes, Lordship, that part has already been.
They have already got 50% of their awarded amount. Now the 50%, our 50% is left. And we are saying that we are not at all liable for payment of 50% because there is no rest and regulation as per the search sheet, ocular evidence, eyewitness, everyone is pointing. And the tribunal has also not discussed how he has come to a contributory negligence, miscomposition negligence. Only the fact is that 2 vehicles is involved, it was head-on collision. Only head-on collision doesn't imply the contributory negligence. So we are saying we are not at all liable, Lordship. So we are asking for full stay. Because the claimant is not suffering, they have already got 50% from the other insurance law.
We are not getting, Lordship, with 100%, so we are suffering.
Do one thing. 50% of the 50% you pay, we are not passing any order of release. Okay?
Lordship.
Then that can be done.
Lordship.
If
you
your
have already
Lordship
received 50%.
if your Lordship,
case or what?
Lordship? It's a debt case. It's a debt case.
If your Lordship is not directing to release, Lordship, then again the petitioner will suffer because that amount, if the amount is hold by the insurance company, that will carry interest.
Now see, there are some point because there some it happens that it is the quantum in regards to quantum or in other regards 10 to 50% can be released. But they are here, they are before this court that they are not at all responsible for 50%.
That is their plea, lordship. That part only your lordship will decide in the final hearing. My lord,
Recovery of again when if it is met, amount is disbursed, recovery will again create some problem. And that case we need a hearing that case. The choice.
We are ready to deposit 50% of our portion of 50%, but release order may not be given. May they file a petition and hearing?
You may file a petition in that case. We'll hear the matter.
Your lordship may impose a condition
Only
that
the question is that they are not, their fees they are not at all entitled. Suppose they are not liable, not at all liable.
with a condition, your lordship may direct to release, lordship, that
Condition. Recovery is not so easy, na. Recovery is not so.
then I may be, lordship, given a liberty to file an application for release.
See, obviously. Mr. B.
Yeah, sorry, my name has not been reflected. Not be reflected. My name also should be.
You are A,
reflected.
na?
A, Acharya.
Mr. A. Acharya, the learned counsel for the Mr. M. Khan and counsel appearing for the respondent number 1 and NMS D does. D does work. D does work for the respondent. This is an appeal right under section 173 of the MV Act against the judgment and awarded it 3007 and 22 passed by MSCT Bongaigaon in MSC case number 170 of the 2000 whereby the awarded the whereby the present appellant as well as the respondent number 2 was directed to directed to satisfy the award and award and no whereby no sorry whereby the present appellant was directed to pay the 50% of the awarded amount. Appeal is admitted. Issue notice to the remaining respondents number 4, 5, 6, 7, 2, 3, 4, also call for the DCA. The estimate accordingly. Mr. IAD, Mr. A. Assaji Tilanet, Counsel for the appellant applicant, and also Mr. M. Khan, Tilanet Counsel, waiting for the respondent number 1 and of the claims. This is an application for stay of the judgment and awarded date 3007 plus 5 member MSCT Bongaigaon in MSC case number 170. The submission made by Learned Counsel is seen that the 50% of awarded amount had already been satisfied by the respondent number 3, that is the regional manager, National Insurance Company Limited, Bongaigaon. However, the connected appeal has been filed by present applicant, whereby the applicant is also directed to pay the remaining 50% of the payment. Next part, Mr. Assaji, however, they are ready to pay 50% of
Because if the 50% comes to 50% of our 50% comes to 3,27,650.
3 lakhs
27,650.
they to pay.
Without
They
interest.
to pay 50% of
50% is 6,55,300.
50% of 50% of the awarded amount, which was negative. Ready to pay the 50% of the awarded amount, connected 50% of the 50% public.
Lordship may say
Award.
25% of the awarded amount.
Huh?
It will be 25% of the total awarded amount. 50%, yes, sir. 50% of that, that is 25% of the total awarded amount.
25% the total awarded amount. Out of the, that is out of 50% of the awarded amount, which comes to rupees 3,27,600 for this day of the operation of the judgment and award dated so and so. Considering the submission made by Mr. As, that the judgment and award dated so and so, the state in respect of the award which is to be satisfied, in the respect of the award which is to be satisfied by the present applicant, till disposal of the connected MSc appeal, with subject to condition of the payment of rupees 3,27,650 within 6 weeks from the date with the above observation descent. However, the petitioner, however, the respondent number 1 and 2 is at liberty to file any interlocutory appeal for release of proceeding.
Deposit within 3 years.
Lordship will deposit within 6 weeks.
6 weeks.
Obliged.
Order.
Number 70.
Look, my junior colleague would like to place me.
Your Lordship, this is an MSc appeal and we are for the insurance company, Your Lordship. Our ground of appeal is only on the quantum of compensation which was awarded by the learned tribunal. At this stage, Your Lordship.
On quantum.
Only on quantum.
So how many respondents are there?
4 respondents, Your Lordship, 3 claimants and 1 owner.
3 claimants and 4 is the owner.
Owner of the way.
So you are MS?
A. Biani.
A. Biani.
Your Lordship, the name of my senior may also be recorded.
Or Mr. A. Biani. Sorry, MS A. Biani, the learned counsel appearing in the learned counsel for the applicant. This is an appeal. The section 173 MP Act against the judgment and award dated 28/8/08/2023, passed by learned member MSCT Sonitpur and MSc case number 32 of 19. It is submitted by MS Biani that basically the present bill has been filed challenging the quantum of the award, which is directly to be satisfied by the present applicant. Appeal is admitted. Issue notice to the all respondents to be post and process. Also call for the DC. Let the matter be according to this as on it. One I you have also?
Yes, Your Lordship, this is a stay petition, IA 51 of 2026. Your Lordship, we are willing to deposit 50% together with interest.
Don't make any payment and the interest at this stage. Let us see. If you are ready, then we can pass the order of payment of the interest. Are you ready to pay the interest at this stage? With the interest, you are ready to pay?
But whatever interest has accrued thereupon can be because there is only a difference of 50,000.
Minor difference.
Amount. So 50% together
Along
with the interest. Accrued.
But we are not passing the order of release at this stage
Yes,
because
yes,
let them appear, then they will.
But
RMS Aviani, the learned counsel, the learned counsel appearing on the application. It's an application for stay of the operation of judgment and quantitative suits by learned suits. Learned suits till the disposal of the item. However, it is submitted to MSBN that they are ready to pay 50% of the awarded amount along with the interest accrued. In view of this, in view of the operation of judgment and awarded insurance to be stayed till the disposal of the connected so subject to payment of 50% of the awarded amount with the date within the 6 weeks. Oh,
Right.
Yes, Mr. Burman, now he's saying that in fact it is charge sheet.
Yes, Lordship.
Yeah, I think you don't have any interim order also.
Yes, Lordship.
Do you have? No.
No, Lordship.
So at least we can pass the order that you may appear before the learned trial court below with an appropriate application. That's all.
Lordship, kindly give a direction to allow the regular bail, Lordship, if possible.
It's not possible at all because your earlier.
I will definitely cooperate with the investigation, Lordship. Kindly direction may be given.
That direction in a sense, if your case is appropriate case, then definitely bail will be considered by the learned trial court. But at this stage, it may not be possible for us to direct the trial court below to pass any order of regular bail. But you can definitely appear. We'll make an observation. Even ancestral
Number lot.
CS number
653.
653.
Stroke 2025. Dated 29/11/2025.
Pune Lutila. Pune Lutila. Yeah, guys. Technical information. Mr. D. Burma, the learned counsel. Mr. K. Kidas, the learned additional PP appearing on sitting of receipt it is submitted by Mr. Das. The learned additional PP that case has already been charge sheeted by CS number 653 of 2025. Dated 29/11. In view of this, Mr. Burman, the learned counsel for the petitioner, submitted that the petitioner is ready to appear before the learned trial court below, and also ready to extend his, also ready to appear on the date, on the date to appear on each and every date. As the case has already been charge sheeted, the present petitioner is hereby directed to appear before the learned trial court below with a regular application for bail, which may be considered in accordance. I have made your submission that he will appear regularly. That part we cannot help you any. Anyway, we are disposing the matter. If your petition is accepted, then it's well.
Deeply obliged, Lordship. May I, Lordship?
Yes.
Lordship, it is a case challenging the judgment and decree dated of learned lower court. Lordship, the substantial question involved in this case is that, Lordship, the appellant number 2 and all respondents, they are from the same ancestors, and Suitland is the ancestral property. So, Lordship, this being an undivided property, none of the co-personer can claim exclusive right title, interest, and exclusive possessions. And what the learned lower court has conferred this exclusive right title interest.
And secondly, Lordship, as per the principle laid down under Dayabhaga laws, the co-person are having the equal and specific share, but possession is not specific, even though some of the co-person are occupied some portion of the land. And thirdly, Lordships, the lower court has discarded the principle of doctrine of necessary party. That has discarded, because it is the learned lower court could have framed up the issues at their suo motu. That has discarded. And Lordship, another.
Why you are saying that it is the cases, the necessary party was not there?
Yes, necessary party. Some parties left. Those are necessary because.
How it is necessary? How they are necessary? Is there?
Yes, because they are connected with
You
the suit.
made any explanation in your.
Yeah, they are the legal. Some of the legal heirs of the respondents.
You are the plaintiff or the defendant there?
I was
original suit?
I was dependent in the original.
You are the defendant in the original suit?
Yes, sir.
The decree was passed.
Yeah.
And then you preferred an appeal.
Yes.
So concurrent decree is
Yes.
there. Achha. Now this issue, you raised the issue in your WS that the case is want of necessary party.
That was not in the WS, Lordships, because it is the learned lower court would have framed up the issues they at their suo motu. But instead doing that, they have not framed up the issues of necessary party. They adjudicate the matter, because without necessary party, there will be no proper adjudication of the matter. And
No. Basically, the plaintiff filed the suit for the declaration of what kind of suit was there. I
Yeah.
have not gone through the time.
Yes, sir.
What was the suit?
Issues were the declaration of right title interest, and issues whether the dependent number 2 having their position is legal or illegal. These are the issues. Your Honor.
No, but you
And
claim that this is an ancestral property.
And confirmation of positions. That's also one of the issues.
This is an ancestral property or what?
Yes, ancestral property. Yeah, ancestral property. That is appellant number 2 and all the respondents, they are from the same ancestor, and these are the ancestral property. Subland is the ancestral property. So whenever ancestral property is there, it is undivided, Lordships. So none of the person can enjoy the exclusive right title interest and possession. But what the learned lower court has conferred the same without taking into consideration. And Lordship, co-personal right came into exist after death of the father. So when I mutate in the property, my mutation how would be illegal? My mutation is never illegal because my rights came into exist after death of my father. That the illegal has committed by the learned lower court.
They claim that your mutation is illegal.
Yes.
So you illegally mutated your
Yes,
name
Lordship,
and
because yes, my right is there after death of my father.
How many issues they have framing? Then the fact also or what?
Lordship,
We have framed or formulated as many as 9 numbers of substantial questions. How?
yeah. Because an even learned lower court even not taken into consideration what is the legal consequences of the unregistered sale deed. Because Lordship, the appellant number 1, he has purchased a plot of land from the suit land from the appellant number 2 by an unregistered sale deed. So whenever sale deed is unregistered, you have never transferred the title and ownership. So that ownership and title remain with the dependent number 2. He is the seller. He was the seller. So that part also has also not considered by the learned lower court. The Lordship, simple things is that it is ancestral property, undivided property. So no co-personer can enjoy the exclusive right, title, interest, and position. And also Dayabhaga laws principle laid down under Dayabhaga laws says the share is specific and equal, but position is not specific. Even if someone else under occupation of some portion of the ancestral property. But learned lower court has conferred confirmation of position in favor of the respondents.
Order of appellate.
Lordship, 71 to 120. 721 to 120. That's
Party.
Lordship.
Yeah, please. In item number 23, my lord, there is a order, my lord, regarding my lord, service upon respondent number 6. The last occasion, my lord, service is awaited. However, my lord, the respondent number 6 has filed an case, my lord, item number 24, lordship. Therefore, my lord, they can appeal, lordship. This is complete.
May I please, Lordship? Lordship,
PCR received, my lord, and all are appeared, my lord. So this matter may be fixed for hearing, my lord. It is
You are for it.
item number 24, my lord. We are appellant, my
In item number 23,
yes.
And item number 23.
here is my lord. Yes,
You
26.
can appear. In item number 23 also you can appear.
Yes, my connected. And
I am appearing for Oriental Lordship in 23. I'm in both the cases actually I'm appearing for Oriental. In 23,
You are
my number. Oriental insurance.
this one number 3.
3.
And in 24. And in 24.
I haven't got the memo of appeal. I have
My lord,
requested.
I think they have struck of response number 4 and 5. I think.
Item 23, my lord, Oriental is response number 3.
3.
There are 3.
Yeah.
No, in 24.
24.
In item number 24, my lord, kindly see the office note dated, my lord, 16/5/18, my lord. All are appeared, my lord.
Response number to number.
Owner and
No, I'm insurance.
response 3. 3.
In 24 also.
In 24, I have no.
My memo of appeal.
My lord, I have not brought my, because my lord, it is misplaced in our chamber, my lord. That's why, my lord.
And Lordship, I haven't got a copy of memo of appeal in 24. Yes. And our names are also not shown in the cause.
Yes. So you are Oriental.
Yes, Lord.
That case. Then 6.
6. Okay.
Oriental.
And 6 has to receive the memo of appeal.
In item number 23, response number 3, and
Item number 24, response number is 6.
6.
First come to item number
23.
23.
In 24. Sorry, in 23. You are for the effort.
Yes.
And then
Yes, ma'am.
and you are going to appear for
6.
and what was the other?
My lord, as per service is completed.
Already completed.
Yes, yes. Last order, my lord, thrown. Except the respondent number 6, but later we find that my lord, respondent number appeared.
It's a matter of 2016, my lord.
In the expiry order dated 59/25, it is seen that the names of respondent number 1, 2, and 4 are already considered as necessary, not necessary.
It's,
Not necessary.
Not my lord.
I don't know. Here it is written, not necessary.
in item number 24, my lord.
No,
23.
23.
Not is
For
owner.
order dated
Is
59/25, it is observed that from the order dated 14/8/25, it is seen that the names of respondent number 1, 2, and 4 are already considered as not.
4.
And
Is
respondent
also
number 5 is already.
Expired.
Number 6 is already.
Look.
Only 6 is.
Look.
Why 1, 2, and 4 are not? They are declared. Not declared. You are not declared.
My lord.
In item number 23, you are declared. No.
No, my
he is
lord.
the
We are
claimant, Lordship.
we both
The
are
appellant is the claimant.
insurance company, my lord.
No, appellant is the
Oh, you are
claimant.
the insurance company.
Yes, my lord.
Okay, that you have already. So why
Lord,
one?
my lord, because my lord, this file is conducted by other council lordship. Maybe my lord, they are the my lord, maybe my lord, performer, my lord, since respondent number 1 is a my lord owner, who is the my lord driver. We are against only the my lord insurance company for enhancing the my lord compensation.
Number 5 is track off, then expired is track off.
Lordship.
He is there. Not necessary, but If you are only on quantum only, na?
Lordship, only for the quantum.
Okay.
Since my lord, they are.
Fine.
Research.
After 4 weeks, 2 weeks,
After 4 weeks, my lord. Any date, my lord.
Only that may
date you need.
lost. My lord, it's a matter of 2016.
Yes.
Lordship, no, I'll be out of station till from 20th to 27th February. Before that or after that?
Second week of March, my lord.
Week of
March, my lord.
Okay. When what?
In 24, who are you?
I am, my lord.
You are appellant. You are
Clement, my lord.
Clement.
claimant.
Hello.
All right. Your phone number.
Maybe like
1, 2, and 3,
one,
I think, my lord.
2, 3, maybe
1,
my lord.
2, and
Copy
3.
is not looking my lord. 1, 2, 3, 1, 2, 3.
1,
And 3.
120.
Yes.
So now in year 24, 1, 2, 3, and 6 already.
Appeared, my lord. And 4 and 5 already served, my lord.
4 and 5, sir.
Served, my lord.
Lordship,
In
I
2018, my lord.
doubt, Lordship, how it can be of wonderful Procedural? Because Lordship, he is for the claimant, and in the other case, 23, Lordship, 1, 2, 4, and 5 were owner and driver, and I was the insurer. So naturally, there is only one claimant.
Plaintiff
So how
copy
can
আছে
he
না?
be of one?
One can see how you must be
My lord, 1, 2, and 3, my lord, is the appellant in the item number 23.
20.
My lord, respondent number 1, 2, and 3, my lord, in the item number 24, is the appellant in the item number 23. Lord.
Oh,
1, 2, and 3. My 6 to insurance.
Approximate tell you.
120.
1, 2, 3. They are the appellant.
It's okay, my lord.
6 is a company.
Insurance company, my lord.
4 and 5. 4 and 5.
4 and 5 driver on right, my
5
lord.
driver is still 20.
Maybe I don't know.
Yes, sir.
Yes, ma'am.
What do you think?
My lord,
Service
in sub, my lord, on 2018, my lord, it is already sub on response number 4 and 5, my lord. But they are not represented by any, they are not counseling. 16/5/2018.
Order.
Yes, my lord.
Order no officer.
Order, my lord, delay condonation, my lord.
Yeah. Yeah. You're fixing both the matters together. Or you think again because in other case, as per their 4, 5 or whatever they are also about whatever their income. May not be necessary. But here already it may be a necessary party because you are the company.
Owner, my lord.
Oh, yeah. So that's why I maybe
Okay, ma'am.
necessary party for it. So it should notice.
Five is died,
But we are listing-
expired, my lord. 5 is expired, so he is not driver is not necessary party, my lord.
5 is there.
So no owner भी हो सकता
हमारा प्रश्न कुछ नहीं है, हम क्या बोले
है. I think 4 and 5, I think
No, no, 4 and 5 died now. Who died?
5 died. 5 expired.
उस वाले केस में डाइट किया.
In item number died also. In item number 23, 5 died. In item number 23, madam,
5 डाइट किया है.
5 died.
इसमें कितना है नंबर?
In item number 25.
My let order may be passed for issue notice, my lord.
Yeah.
Yes, my lord. Issue notice on.
5 number 5 taken on it.
उनके पास है ना एप्रिल को. ना ना मुझे
दिया नहीं.
हम लोग को नहीं.
He's not, he is Sanjeev Kumar.
Pardon?
Who died in December 23. Number 5 is Sanjeev Kumar.
Sanjeev Kumar.
Sanjeev Kumar. December 24. If you notice,
Yes. 24.
both the papers they received together.
Highly obliged.
Obliged me.
Deep level.
Yes, brother Pranjal, you can
Yes.
deliver the judge.
We do not find any infirmity in the conviction of the appellate. And according to the said conviction under 302 IPC and section 27 of the Arms Act is hereby upheld. The prison terms are also upheld. The fine amount is reduced to rupees 1,000. The criminal appeal stands disposed of. Okay.
Regarding the part of
Highly offense.
Yes, yes. One or two just corrections remain to be made. We'll make it and then it will be uploaded by tomorrow. Okay.
Acquitted, ma'am. Your lordship.
No.
The criminal
The
appeal
appeal
is
is
dismissed.
dismissed.
The criminal appeal is dismissed. The conviction and sentence is upheld. But the fine amounts have been reduced. Okay. The
Okay.
criminal appeal stands dismissed by upholding impugned judgment and order. Okay.
Okay, your lordship.
Okay.
Highly obliged.
Okay.
May please, Your Lordship. Lordship will find the office note dated 7/1/26, my lord. LCR has been come, my lord.
LC has already received.
Yes, my lord. And
You are for the respondent. How many respondents? Sole respondent?
no, my lord. Two respondents. Service is complete as per order dated 10/12/2018. So, Lordship may fix this.
You are appearing for the respondent number 1. 1 and 2, both the respondents. Yes, another.
দুজনে Lordship may
One is pro forma respondent otherwise.
Yeah.
So you are appearing for the respondent number 1, depend.
Yeah.
Substantial question of law has already been found.
yes, my lord.
So it has been admitted.
Yes, my lord.
So
Lordship
we
may fix
will-
this matter for hearing, my lord.
For hearing.
My lord. Appeal admitted on 3/9/2018.
You are Mr. R.
My lord.
Sharma. Part Mr. R. Sharma. Sorry, appellant and also but name is not here.
My name is not.
You are appearing on behalf of
Mr. A. Roshid.
your good name.
T. Begum.
I just forgot. MST Become appearing on leadership for the scan copy of PCA has already been received. Sorry, scan copy, not this scan. PCA has already been received. It is already admitted for hearing. Services complete. The matter listed for hearing for
In usual course.
third,
Usual course, my lord.
in usual course as on a date to expect.
Congrats.
57.
And represent none is none appearing on behalf of the appellant. The matter be accordingly listed up to 3 weeks as an
Okay.
Lordship, my senior Mr. S. Committee is out of station. Kindly make
why what is the IA for it?
delay, condonation of delay.
What was the delay?
815 days.
Have you filed any objection here?
No, we have no objection.
We don't have any objection. If delay is condoned, then matter can be disposed of.
Yes.
I can be disposed of.
I can be disposed. You are Mr.
KK Medhi.
KK Medhi. Pardon, Mr. KK Medhi appearing on behalf of applicant appellant for the appearing on behalf of Mr. SK Medhi for the applicant appellant. Also heard Mr.
MS Hussain on behalf of S. Parveen.
MS Hussain on behalf of MS S. Parveen. Mr. MS Hussain appearing on behalf of MS S. Parveen for the respond number 1 to 6.
1 to 6.
1 to 6. And
Secure on behalf of S count, respondent number 9.
appearing on MS S. Sakya appearing on behalf of Mr. S. for the respond number 9. It's the application section 5 of the limitation. Read Rule 3A of Order 41. CPC for condonation of delay of 850 days in referring the connected application. Where you have, I mean, you know that where your grounds of delay has been mentioned in which para? Can you tell us? In para 3, there is a statement that the case on behalf of so handled by advocate 1, advocate Habibur Rahman. However, he was not contactable, though any means and due. In view of this situation, the applicant supports Indian Solicitor General of India. Yes.
Mainly Lordship COVID-19 due to COVID-19. The paragraph number 17.
So, the Union of India was once represented by Mr. S.C. Kyle, the didn't represent.
Yes.
So you are the Director General of Civil Aviation. Who are you?
I'm Union of India. I senior Mr. S.K. Mathis, Central Government.
You are for the Union of India.
Yes, both the applicant.
For both the applicants. So Mr. Medhi is a senior counsel or who is
Central Government Council.
central government or CGC?
CG.
SK Medhi देखो CGC. Next part. Yes. Mr. Medhi further submitted that there was no intentional laches and negligence on the part of the applicant happen, but because it's some delay is caused during COVID-19 as well as from some for to observing some official public to its council to represent the Union of India. Which has already been explained in para. You are saying para 17.
Yes.
The application further submitted that due to COVID-19 as well as the change of Assistant Solicitor General of India, there was some delay in preferring the connected app, which was preferred against the against the judgment and order passed in money suit number 79 of 2006 by learned civil judge number 1 Kamrup M in Kamrup M date 17 court. Mr. Hussain advertisement very obvious raised of that the delay may be conducted and the connected if delay is conducted if connected appeal is admitted by convening the delay, the respondents have competition. Next, hearing the submission made by learning considering the grounds mentioned in the petition, which are considered to be reasonable ground of the delay of 815 days in preparing the connected appeal is hereby raised is accordingly directed to register and number the connected RFL into list with the above configuration, the present height distance.
Deeply obliged.
Please, Your Lordship. My lord, in this case, my lord, of notice is served on 1 and 3, my lord. And opposite parties name may be opposite party 2 may be struck off, my lord.
Whose name?
Opposite party number 2.
Huh?
2. Opposite party number 2. Otherwise, service is complete.
Why do you think that 2 is not necessary?
No, because actually, my lord, necessary party is respondent number 1, OP number 1. Because of his fault, the petition, the applicant could not participate in the auction process, because the for the auction EMD pre-deposit of EMD was required. They could not debit the amount in time, my lord, and send the amount to a wrong number, which was reversed back. In the meantime, time expired, and as a result, he suffered loss, which could not participate in the tender process of that auction.
But now this number 2 and 3 most probably they got the tender or what?
No, number 3.
Number 3.
3.
And how 2 is related? 2 is not related.
2 actually is another government company, but actually tender was floated by respondent number 3.
Only the respond number 3.
3.
What the office note says is already served.
2 is not served. 3, but 1 and 3 served.
1 and 3 served.
Delay is explained at paragraph 3, my lord. Though notice and nobody appeared for the 1 and 3.
Now, where from you are saying that respondent number 2? Oh, you have. I mean, you have not taken steps at all.
No, man, that is not. That is why we have not taken. Because of the State Bank of India, he could not participate in the tender process. That is why. And 3 floated the tender.
So on behalf of 1, no one is appearing?
No, neither on behalf of 3. 3, sir, there is a notice of the Jari Karak.
Pass the order today. Just make an observation. You are Mr. Roy?
SK Chakravarti.
SK. Mr. SK. I to take the returning consequence. What was the delay?
147 days, my lord.
Property for the from the office note. It reveals that the service is completed on respond number 1 and 3. However, no one has appeared to represent the respond number 1 and 2. Mr. Chakraborty further submitted that respond number 2 is not necessary party, so his name was mentioned in the billment and accordingly paid and accordingly submitted the name of respond number 2 may be strike the cost. Present present application as well as from the bill memo. Next, considering the submission made by the council for the name of the is hereby struck from the cost debit of the present I. The registry will do the need. Further, seen that the service is already complete. Let the matter be accordingly listed. We try to give some time in fact. So we are listing it on after 2 weeks we'll do. After 2 weeks. You want any date or?
No.
Let the matter be accordingly listed after 2 weeks.
Problem.
May I please, Lordship? Lordship, delay of 47 days, Lordship.
47
7 days. Notices were issued, Lordship, and the respondents have duly received the same. Order received, Lordship. Order dated 7/8/24, Lordship.
17.
7/8/2024. Order dated. Passed by this Honorable. Wherein the order dated 25/7/2023 of
1
Lazima
to
Court.
6. 1 to 6.
1 to 6.
Okay, now what is your delay? 47 days.
47 days. Explanation at paragraph 4 and 6, Lord.
No. Office made any calculation?
Lordship?
The concerned section made any calculation in that regard?
Yes,
Because
yes.
earlier
57 days.
it was.
Yes, altogether 137 days was a delay. After counting that period of limitation of 90 days, 47 days delay.
So basically you are saying that for the puja vacation and
No, but in the meantime,
delay in obtaining the certified copy.
yes, yes. And also in the meantime, during that time, he was at Ambala. His son is an Air Force officer. At that time, he was staying with his son, and there he was having some problems. He was admitted in military hospital, Lordship.
Oh.
The petitioner. So he was not there. Thereafter, he came to know that the order was passed. He requested the council, Lordship. At paragraph 7, I have stated at Lakhimpur, Lordship. Thereafter, certified copy was applied, and on the reopening day, the appeal was filed. From 2010 to 5/11, High Court holidays was there.
That's from from the order date 7/8/2020 that from the order of the that the Plausible court had passed an order where is seen that the service is already completed on respond number 1/6. But till date, no one has represented the respondents. This is an application section Probability Limitation Act bring for following delay of 47 days in preferring the connected appeal against the order dated 26/05/2023 passed by Learned Civil Judge Senior Division in Ms. J case number 4 of 2003. Next para is submitted by Mr. Chauhan that the present applicant appellant during the after the the appellant was staying with his son at Ambala and was also fallen sick during that period, and hence when they came to know about the judgment, there was a long vacation, Puja vacation, and thereafter only he made a request his counsel for obtaining the certified copy. Obtaining certified copy of the judgment, the appeal has been preferred against the order dated so and so state. If what is submitted, there is no willful negligence latches on the part of the but due to state unable circumstance, the appeal could not be preferred within the period of application. Next, considering the submission, considered the grounds mentioned in the petition, which are found to be reasonably justified ground. The delay of 47 days in preparing the connected FAO against the order dated so and so past date music is not so and so by that so and so is hereby is hereby condoned. The registry is accordingly directed to list number and register and number the collected and to list with the
Pleasure.
31. May I please, your lordship. This is the transfer petition, lordship, under section 24 of the Code of Civil Procedure. So a petition on the response.
you have appeared.
So the petitioner is and the respondent, they are resident of Nagaon, lordship. And in an earlier litigation before the district judge at Nagaon, lordship, in fact, the respondent and earlier.
No, you have already filed your affidavit.
Yes, affidavit in position is fine.
So you are representing respondent number 1.
She is the sole respondent.
Sole respondent.
Yes.
But we are not going to hear the matter today. Difficult way.
Short date may be given, your lordship.
In admission column,
May come up for admission in
admission here. Mr. Egan and it comes to the petition. And also her Ms. H. J. Hayat, represent the sole respondent has already filed their affidavit in position. Let the matter be accordingly listed in admission column. After 2 weeks or 1 week, do you want any date here?
Let it come up after 2 weeks.
After 2 weeks, as a date to be picked by the registry. Well, interim was there.
Lordship?
Interim was there.
Yes, interim is there.
Interim be continued. After 2 weeks, it will be listed.
Next.
Publish.
May I please, your lordships, here the trial court records has been received. Your lordship kindly see the office note that it's 7/1/26.
7/1.
My res
Now here,
respond
your
number.
scan copy is already received. You are representing
I am
whom?
for my lord respondent number 1A to G, my lord.
One is complete, my lord.
1A to 1G. That means
One
one
A
is
to
complete.
one Z. One is complete.
One is completed. And
So far-
answer return for the response number 2, 3, 4, and 8.
2, 3, 4, and 8 already died. The in usual
Sorry,
process
died.
And so far
2, 3, 8. And
then my lord 5 received. In
5,
received.
5, 6.
5 received. But on behalf
6 also received.
receive 6, 9, 10.
5, 6,
9,
7.
5, 6, 7, 9, 10.
10 is not there. 9, 11.
9, 10.
So 10 is not here.
Page number 6, my lord, respondents column, it is office note, my lord. In usual process, it is reflected, my lord. 6, 7, 9, and 10. It is received by respondent number 5
Yes, 6, 7, 9,
and 10.
10. It is received by 5.
Received by 5, the brother. So for element 234, the steps by usual process was not taken. So we have to take fresh steps by usual process for 11 to 34.
2, 3, 4, and 8 expired in that case. They have
We have to
already
take
expired.
substitution. 2, 3, 4, and 8.
Yes, 2, 3, 4, and
8. We have to file substitution. So for 11 to 34, we have to take fresh step.
Partnership and it comes to be.
HR Ahmed,
the Learned Council appearing on behalf of the respondent number 1A to 1G. Next part. From the report, office note dated 7/01/2026, it reveals that the service is completed on respondent number
5, 6,
1, 5, 5,
6, 7, 9, 10.
7, 9, and 10. And the respondent number 6, 7, like 10, how are you saying?
5, 6, 7, 9, and 10. Service complete because
5,
respondent number
6, 7,
9 and 10.
Who expired then?
Expired 2, 3, 4, and 8.
And the respondent number 2, 3, 4,
and 8.
and 8 already are expired, already expired. And service is still awaited. Service report is still awaited for the respondent number 11 to 34.
11 to 34.
In that context, Mr. Fox submitted that they have not taken steps through usual process for the respondent number 11 to 34. And 11 to 34, and then the this will be issued through usual process first. Scan copy of TCR has already been received. Further, next para, considering the note office dated 7/01/2026, the petitioner is also hereby asked to take necessary steps for substituting the legal heirs of the respondent number 2, 3, 4, and 8, who are reported to be. So at this stage, awaiting service for 11 to 34.
11 to 34. We have to take first step.
The next part, the petitioner will take necessary steps in filing the substitution petition as well as taking steps for the respondent number 11 to 34. This matter according after 4 weeks will get the matter accordingly. 4 weeks your stay is there.
Interim order may continue.
4 weeks and interim order will continue till next day.
Obligation.
How did you know? It not be received. Scan copy PCR not be received. But the distributed.
In the receipt, there is delay of 55 days. Respondent number 1 has appeared. 2 and 3 is yet to be served. As per official dated 7/1/26.
How many days delay?
55 days.
You are 1.
Yes, Lordship.
2 and 3, service is still awaited.
Yes.
Let it be awaited till next listing. I was 55 delays.
55 days.
So you are the claimant.
Yes, Lordship.
Next day we see if we may pass out. Part Mr. A.J. Second, Learned Counsel for the applicant appellate. And also part Mr. N.J. Chaudhary, FPD for the respondent number 1. Member from the it repeats that the service is still awaited for the respondent. Let the service be awaited till next listing. 3 weeks will do, I think. This matter accordingly after. Let us see if it comes.
Lordship, here in this case, we will file rejoinder affidavit subject to the petition filed by the respondent here.
So you have filed your
Lordship.
affidavit.
Affidavit no point.
On Lordship 31/10/2025.
There are some of the issues are there which have to be clarified here, Lordship, in this they are sent.
You are for 1, 2, and 10. 1, 2.
1, 2.
1 and 2.
1 and 2. They are the main party here, Lordship.
You are for
State government is there.
your state respondent. You also want to submit any your affidavit in opposition or no, not required?
IGGL is the main party here, Lordship, in this case, which is component by the all sectors in Assam. So he is the main performer.
Dr. T.N. Gopal, the Learned Counsel for the petition. Also heard Mr.
P.P. Sharma.
P.P. Sharma appearing on behalf of respondent number 1 and they have already filed their affidavit. Also heard MS, your good name? P.P. Bora. Sorry? T.D. T.D. Burma, additional government advocate. Sorry, additional senior government advocate, representing the respondent number 3 for state respondent number 3. Next para, Mr. Gogoi, the Learned Counsel for the applicant. Petitioner has submitted that in case some time is required to file their affidavit in reply against the affidavit in opposition filed with respondent. Prayer allowed. How many weeks you need?
1 week. Within 2 weeks, I will.
2 weeks.
What's a date maybe fixed?
You want a fixed date?
Lordship.
Let the matter be 2 weeks after the date. 12th of February will do?
Lordship.
Let the matter be accordingly listed on 12 to 25. 26, enabling the petitioner side to file their affidavit.
Diploma.
Metal. In this case, LCA has been received, Lordship. Maybe fixing the admission column after 5 weeks.
Admission column.
Admission because LCA can.
The respondent number? How many?
Sole response.
Sole response.
Yes, Lord. The date may be fixed. Can it be taken on 13th of February, Lordship?
Starting to second.
You are Mr. Hajarika? Demo.
Demo anta.
Mr. Demo. MS.
Peace or yellow.
Speech over here appearing for the source. TCR has already been received. Matter may
What
be,
is it?
matter be accordingly listed for admission. Yet within after 3 weeks as an date. 3 weeks will do.
Sir.
Is there any
No stay order. No nothing.
caveat was there? Na?
Yes.
We will discharging the caveat.
Date may be fixed, Lordship. On 13th of February,
13 you
if
want.
possible, Lord.
Okay.
Oblige.
Apply.
We will discharge.
May I please, Your Lordship? As per the office note dated 19/1/26, the service upon the respondent is still awaited, Lord.
Respondent number?
All the respondents awaited. Actually, 4 and
All the respondents are awaited.
Lordship?
All the respondents
Yes,
are
yes.
Let it be awaited for next date.
A date may be fixed, Lordship. Because I have some urgency. The stay was not granted on the other day.
Mr. T. Kalika, the next for the petition from the store date 19/01/2026, seen that the services awaited for respondent number 1. Let the service be awaited in next date of listing. You want to fix it here?
Yes, Lord.
Sixteenth of February.
Oblige.
37.
My lord, please. My lord will take up IA number 3026 for a moment, my lord.
306.
My lord, this is an
This is a condonation.
yes, my lord. It's for condonation of delay, my lord. There's a delay of 334 days delay, my lord. The reason for the
334.
yes, my lord. The reason, my lord, I do not want to trouble the court, but let me summarize what has happened. So it arises. This is an appeal against an LA case order, my lord, where the reference case, an order was passed. Subsequent to the passage of the order of reference case,
Just a second, I'm just interrupting. So you are representing whom?
if my learned friend is objecting, then I'll
1 to 5.
1 to 5.
1 to 5.
And now he is going to submit regarding the delay of 334 days. Do you have any? Do you want to submit any your written objection or verbally you want to?
I'll submit my objection verbally.
Objection verbally.
Yes.
And the government side is also there, na? Huh? Respond number 6. So you are representing 1 to 5.
1 to 5.
Okay. Yes, you can submit.
my lord, please. Grateful. My lord, what had happened? Let me give you the background of the matter so that my lord, I can take the court this. So this is an LA appeal, my lord, which has been filed by IIT Guwahati against a common judgment of a reference case, my lord. That my lord will after the passage of the common judgment, my lord, they filed a review petition because in the common judgment, the interest under my lord is aware that in LA cases, interest is also granted under section 28. So they filed a review petition against the common judgment. That review was instant pending. This review was pending by now on that point of time when we filed this case, that review was pending. Let me rephrase myself.
No, when this case.
Yes, my lord. This case.
At the time of filing this case.
That review was pending. That review was pending on that point of time. So, my lord, thereafter, what has happened? The order, my lord, will now turn to page number 7, my lord. Let me take this honorable court through para number 9. So, my lord has turned to page number 7. My lord is, yeah. Let me read the para number 8 for my benefit, my lord. Then I'll go to para number 9. That after para number 8, my lord, starting with paragraph number 8, that after receiving notice to the above reference cases, IITG, that is IIT Guwahati, appeared in the said cases being represented by the registrar for being aggrieved by the act of implement of IIT Guwahati as an opposite party number 2. The institute had filed petition dated Iman in each reference cases on behalf of IIT Guwahati before the learned reference course, praying for a striking of its name. Let me pause here for a moment and let me give a little bit background of this case, my lord. In all reference cases till date for the land acquisition of IIT, IIT was never made a party. This is the first reference case where IIT was made a party. Because the convoluted logic which the learned reference court used is this, that the money had passed through IIT, so IIT is responsible. I will take this honorable court to that order also. So once we received the notice, we said that we are not party because my lord is aware, acquiring party and requiring party is there in 1894 law. IIT was not acquiring party. Acquiring party was DC Kamrup, that is the option number 2 in this case. And requiring party in this case was originally, my lord, the central government, because it is between the central government and the state government. They decided to acquire lands for setting up of IIT Guwahati. IIT on 1991, when the land was acquired, IIT was not in existence at all, my lord. No, for the first time, when IIT was made part of a reference case, IIT objected to that for striking of their name. But that petition remained pending in the court CA. Then paragraph number 9, my lord, the learned reference court took up both the reference cases. Paragraph number 9, I am reading, my lord. That is reference case number 83 of 2016 and reference case of 84 of 2016. Together for hearing as the same issue were involved in both the cases, and parties of both the cases are of the same and disposed of both the cases by passing a common judgment of 23/2/2024. On the issue of striking of the name of IIT Guwahati, learned judge had observed that Institute IIT Guwahati is a beneficiary as the land has been acquired by government for the purpose of establishing IIT Guwahati, and as such the IIT Guwahati is a necessary party. In the reference case, therefore, IIT Guwahati is liable to pay compensation to the petitioner landowners in the connected reference case as per the modified order as order was passed. That is the first order of 23/2/2024.
In the reference case, only IIT was made.
No, my lord. The OP number 1 was also there. OP number 2 is also there. That is the state government. The logic, as I was telling, my lord, why the rationale was used. The rationale was used is this, because the money has gone from IIT. How money, my lord? Central government had, because this state government and central government were in communication for the release of the money. Central government deposited that money for probably administrative convenience, my lord, to the IIT's account. IIT transferred that account to the OP numbers 2's account. And those monies were then onward transmitted to the landowners, my lord. Thereafter, my lord, para number 10. This is my cause of action starts. We file immediately after because we were not challenging, let me rephrase myself, my lord. We are not challenging the quantum of the order. We are only challenging here is my inclusion as a necessary party. So, my lord, by using that logic, we first preferred in CRP. And unfortunately, the revisionary court did not agree with our submission. And by the order dated 22/5/2024, that my lord will find in page number 10. Sorry, para number 10. My lord has come to page number 10. That being aggrieved by the above finding of the common judgment dated 22/5/2024, Institute IIT Guwahati initially filed a civil revisionary petition under Article 227 of the Constitution as registered as CRP number 66 of 2024. It is pertinent here to mention that the Institute Guwahati appellant has got no objection against the enhancement of the award made through the common judgment. The appellant's grievance are firstly observation made by the common judgment as a beneficiary of the acquisition, and secondly the direction given the said judgment to make payment. That is our only grievance, because the enhancement part is straightly in the realm of OP number 2, my lord. Then 11, that the above CRP, that is 66, was taken up for the Honorable Court such and such on 21/6/2024, and Honorable Court has observed that the LA Act 1894 itself provides for the preferring of an appeal of the said act, and therefore the revision is not maintainable. And my revision therefore was dismissed. And by the order dated 21/6/2024 was dismissed, the revision was dismissed. However, the same order of revision granted liberty to prefer an appeal, my lord. That thereafter, my lord, on examination of the revisionary order, my lord, the authorities of IIT wanted to review that order, because in our understanding, there was a point which the Honorable Court did not consider. We filed a review against that CRP's order. That review order was also against us, and that order is of 19/7/2024. That, my lord, will find in page number 9. Now, my lord, thereafter, my lord,
What did you do after?
After the review-
21/06/2024?
my lord, sorry,
After dismissal of your revision petition?
we filed a review. We preferred a review because certain facts were not.
Okay, you did not prefer any appeal and you filed a review.
We filed a review first, because certain points which the IIT believed he was not made to the notice of the court, we filed a review of 9, and my review ultimately was not decided in my favor. 19/7/2024, my review was dismissed. But my liberty was granted. That liberty stood with me, and the review order of 19/7/2024 carried forward that liberty. That is my submission, my lord. Thereafter, my lord, para number 12. That, on the other hand, subsequent to the passing of the common judgment, the claimant respondent had filed a review. As I told, my lord, they have challenged the review petition on all the reference case order. They have challenged it through a review, because according to them, some interest component was not calculated. In the reference court, praying for a review of the award provided by the said common judgment by adding some interest to the said award. The said review
That is there, but that means
So,
preferred a supposed review against that awarded.
my lord.
Awarded compensation was not interest was not calculated or whatever.
Yes, my lord.
There is a-
So that was pending. That was so my delay, which I am agitating before this honorable court, is this that delay of 334 days has occurred because the matter was sub judice before the revisionary court and before the review court, and that is absolutely cleared is covered by section 14 of the Limitation Act, my lord. My lord is aware of section 14. If my lord permits, then I'll read the section 14. Otherwise, I'll not trouble the honorable court. My lord, if my lord, I have judgment also, my lord, how Supreme Court in a full bench in the matter of Consolidated Engineering Enterprises versus Principal Secretary of Irrigation and others.
Which para basically you?
My lord, I'm handing over the judgment. My lord. My lord, it will be convenient for this honorable court to.
It's okay. In which para you have cited your the grounds of delay or the?
My lord, it is my on para number. It starts from para number 10, 9, 10, 11, and 12. Specifically 11, I have told how this thing has happened. Thereafter, my lord, para number 13, specifically, I have said that the liberty which was granted to me, that continued till, if my lord wants, then I'll show the order for a moment. Annexure B and C are the order of revisionary court. If my lord turns to page number 29, it starts, and 30 is the operative part which I'm relying upon, my lord. 30 is the petitioner is, however, at liberty. My lord has come to page number 30. At liberty to prefer an appeal accordance with law. Thereafter, my lord, we have filed a review
That, my lord, review order will find in page number 31. It starts, my lord, and it ends at 33, where the after the review has occurred, my lord, we have filed this appeal, and we have challenged in the appeal, as my limited prayer in the appeal, as I've already summarized, my lord, is not against the quantum what has been increased. I only on the merits. So my humble prayer as of now is this, my lord. Let the delay be condoned, and I am relying upon one judgment of Supreme Court. If my lord had not wanted to travel, I thought my learned friend will be accommodating on the delay part so that appeal can be taken up. But be that as may, my lord. I have marked the quoted part, my lord, for the reference of this honorable court. This is a full bench judgment, my lord. Otherwise, so my lord will turn to page number 172, which I have marked, my lord. The policy of section 14 of Limitation Act is to provide protection to the litigant against a bar of limitation when he institutes proceeding which by reason of some technical defect could not be decided on merit and is dismissed. Specifically my case, my lord, my question was not decided on merit, it was dismissed on a jurisdictional ground. A line thereafter, my lord, while considering the provisions of section 14 of the Limitation Act, proper approach will be to adopt, proper approach will have to be adopted and provisions will have to be interpreted so as to advance the cause of justice rather than abort the proceedings. That is my humble submission, my lord, that the delay which is occurred here specifically, my lord, it is not because of any error or any lack of diligence on my part, because IIT was not challenging the quantum, my lord. The quantum can only be challenged if they are aggrieved by the state government, because state government has, my lord, under 1849 or 1894 Act, my lord, is aware. The calculation has been done by the collector himself, and nobody else can collect, do the calculation. So if the state government feels the award is higher, it is them who has to challenge the award. As we are only before this honorable court through this appeal is because we were aggrieved by the us being included as a beneficiary. Now, my lord, before I rest my case, let me put some facts before this honorable court. My lord will take up for a moment. Now, I have filed an affidavit also. That, my lord, will find it is dated 12/12/2000. Sorry, it is, I think, 11 December 2025, my lord. Is the affidavit has gone, my lord, has come to that additional affidavit. Is page number 34, my lord. Now, I understand, my lord, that my learned friend might have been, his client has not got a penny and the land was acquired. That is specifically the reason the proceeding was actually happening in the adjacent court, because the coordinate bench of this court has taken up this issue, my lord. Where what they have done under WPC, that is what I have specifically stated in paragraph number 3, that in WPC number 92 of 2023, State of Assam versus Dilip Thapa, in this case, my lord, all those people who were landowners, their common cause is this coordinate bench is hearing. And after a meeting between central government and state government, my lord, the DC Kamrup has calculated an amount of 5,24 lakhs, which this landowners, including my clients, my learned friends' clients are also there. I will take through this honorable court that particular page also, my lord. I do not know the abscess, the reluctance on the part of the OP number 1 here, page number 59, my lord. DC Kamrup had a meeting, state government had a meeting with the central government. They finalized the amount, and that amount has been deposited. Page number 59 for a moment, my lord.
Okay, this will come. But your question
So
is that
his prejudice, if it is anything, my lord.
Party in this case, isn't it?
The prejudice, if any, my lord, let me rephrase myself.
His only grievance can be this, that I have not received the money. Money was deposited by the DC Kamrup's account. They must have approached this honorable court in that other proceeding, and they could have become party, and this issue could have been easily sorted.
That is their fact.
I'm just bringing this honorable court's notice because this otherwise this development has proceeded. The money has been deposited also. They have to figure it out whether this money is their amount, correctly calculated, not correctly calculated.
Now see, these are their
Their
question.
obviously, my lord,
Question
obviously.
is that your inclusion as a necessary party in this case, you are agreed to that.
I am
So
agreed.
now
Right.
you have submitted that under section 14, your delay has been, that your cover
My lord,
protection is
my
there.
lord.
That much only.
My lord.
Yes.
So my submission is precisely on that, this section 14, whether it covers all the time years and all. So before coming to this, regularly, I just bring this back to your lordship's notice that the land acquisition process has been started in 1991, and I was technically dispossessed in 1995. So it is a long pending. So now, as per submission and the records, my lord, the CRP that was filed on 22/5/24, para 10, it was dismissed by order dated 21/6/24. The order is at page 28. At page 28, this 29, second para. The aforesaid judgment and order dated 23/2/2024 was passed by the learned court below as a reference under section 18 of the Land Acquisition Act. The Act provides for preparing an appeal under section 54, and when the statute itself provides for an appeal, a revision is not maintainable. So this is a categorical statement of law, whether the CRP was maintainable or not in view of the appeal. So despite this, the applicant waited for a long time and filed a review. And this period from 21/6/2024 until the disposal of review petition or the filing of this instant appeal, which is the date is 28/4/25. So from the date of disposal of the review, the CRP on 21/6/24 up to the date of filing of the appeal, which is 28/4/2025. This period is not covered by section 14, because section 14, I just want to refresh your lordship's memory. The main key phrase in the section is good faith. May read the section. Exclusion of time of proceeding bona fide in court without jurisdiction. Bona fide. In computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in a court of first instance or of appeal or revision against the defendant, shall be excluded where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court which, from defect of jurisdiction or other cause of a like nature, is unable to entertain it. This will suffice. So the good faith is defined in section 2, clause H. Good faith, nothing shall be deemed to be done in good faith, which is not done with due care and attention. So my point is that since this honorable court has held that revision doesn't lie, categorical statement has been made. And after that, appeal was not preferred, and more than 300 days were left to be passed. This is not done in good faith. There is no due diligence there. And
In support of my submission, I want to produce a judgment of the Honorable Supreme Court. This is a constitution judgment. Where in this case, what happened, the opposite party indicated that the proceeding is not maintainable. And despite that, this what is that? Despite that, the petitioner therein continues with the suit. The Supreme Court held that since it was indicated, it was argued that this is not maintainable, and the insistence on the part of the petitioner to continue with the proceeding was not in good.
Citation.
Citation is 1973 3 SCC 381. Can you see the head? Held. It is clear that
Para, in which para you are relying?
head note.
Oh, head note.
So held. It is clear that no suit for declaration and possession could have been filed against the defendant in respect of revenue sales which were set aside against without impeding the government. That was the subject matter there. The objection to the maintainability of the previous suit was raised at the very initial stage, but that was resisted and the appellant invited a decision by the district munsi. Even at the stage of revision against that order to the High Court, he took the risk of proceeding with the suit. This was therefore not a case of proceeding, prosecuting the previous proceeding bona fide. It is not a case where the plaintiff prosecuted due to ignorance of law or bona fide mistake, nor it can be said that he had misconceived the suit. There is therefore no justification for the application of section 14 of the Limitation Act. Paragraph 4 explains the law. This is just gist. I'm reading paragraph. After the suit was dismissed, the plaintiff gave a suit notice to the government under section 80 of the Civil Procedure Code and thereafter filed a suit in the court of the principal subordinate judge, so and so, a similar nature as that earlier filed in the district municipal court. During the pendency of the suit, the plaintiff died and plaintiffs number 2, 6 were impleaded as his legal representative who are the appellants in the case. Defendant number 1 to 5 as also the state of Madras, the 7th defendant, apart from raising the various defenses, contended that the suit was barred by limitation in respect of which an issue was raised. So this maintainability was raised there. The subordinate judge held on this issue that the suit, which was filed on so-and-so, though filed long after the expiry of 12 years from the date of the next revenue sales, nonetheless was not barred because the plaintiff would be entitled to exclude under section 14 the time spent in prosecuting the earlier suit in computing the period of limitation, and after this period was excluded, the suit would be in time. Some of the other issues were also decided in favor of the plaintiff. Consequently, the subordinate judge decreed the suit with past and future mentioning profits. In appeal, the High Court of Madras, as stated earlier, came to a different conclusion on the question of limitation. It held, agreeing with the findings of the subordinate judge, that the auction purchasers in revenue sales never took possession, nor were their alienness or a plaintiff ever in possession, or alien is or a plaintiff ever in possession of the suit properties. After this finding, the High Court proceeded to consider whether the appellant was entitled to exclude the time taken in the prosecution of the previous suit under section 14 of the Limitation Act. It was contended before that court that the plaintiff was bona fide in filing his suit and prosecuting it and the appeal, and therefore he was entitled to exclude that period under section 14 of the Limitation Act. This contention was negative with these observations. From what we have stated above, it will be plain that the appellant took objection to the non-impleading of the government as a party at the earliest possible opportunity. The respondents would not take note of this of that objection. They persisted in their attitude till ultimately the High Court of Travancore, Cochin held that the suit will have to fail for the non-impleading of the necessary party. A request was made to the High Court to permit the respondents herein to remedy the defect. The learned judges held that they could not accede to that request and that the suit has to be dismissed as in spite of timely objection raised by the defendant on the ground of non-joinder of parties, the plaintiff persisted in proceeding with the suit, undertaking to bear the risk of not impleading the Sarkar. This attitude on the part of the respondent is sufficient to dispose of the question of bona fide against them. Mr. B.V. Raghavan argues that the fact that two subordinate courts in the previous litigation had held that there was no need to impede the government as a party to the suit would itself show that respondents were acting under bona fide mistake. As we have pointed out earlier, the defendants took objection to the non-impleading of the necessary party even at the earliest stage. The matter went up to the Travancore High Court. The respondents did not want the High Court to decide the question as to whether the government was a necessary party or not, on the ground that they were prepared to take the risk of their omission on the to implead the Sarkar, and on that ground got a dismissal of the revision petition filed by the appellant. Under these circumstances, we cannot accept the contention now urged on behalf of the respondents herein that they bona fide instituted the previous suit. The reasons given by the High Court are in our view cogent. Section 14 of the Limitation Act, which is applicable to this case, gives benefit to a party who has been prosecuting with due diligence another civil proceeding, whether in a court of first instance or in a court of first appeal against the defendant, where the proceeding is founded upon the same cause of action and is prosecuted in good faith in a court which, from the defect of jurisdiction or other cause of the like nature, is unable to entertain it. The appellant's advocate points out that under section 2.7, which is now 2.8, nothing shall be deemed to be done in good faith, which is not done with due care and attention. And that in this case, the appellant was bona fide in purchasing the suit properties from an auction purchaser who also purchased them in revenue sales bona fide, and that without notice to either of them, the sales has been set aside, which is totally without jurisdiction and injuriously affects the appellant.
Okay, I have understood.
Yes. So the main point is that this honorable court once pointed out that this is not maintainable, and then at that time, if that was bona fide mistake, they should have filed the appeal. Instead, they wasted time, and this time is not covered by the section 14. And this is the ratio of this judgment. This is the constitution judgment. Constitutional judgment. So this is this, and I'm not making any submission on merits, but I have to add that this the review on the reference judgment on the judgment of the reference case that we have sought was disposed of, and that review was allowed. So the order passed in the review is the order now in force. This order, which is the subject matter of this appeal.
The review petition filed by you was pending is already disposed of.
Disposed of.
Now
13/6/2025. It was disposed of on 13/6/2025. So now the order, which is the subject matter of this appeal.
When it is disposed of?
13/6/2025, correct?
Yes, 13/6/2025. So now the order, which is the subject matter of this appeal, is no longer in existence in the eye of law because this is reviewed. So the appeal also doesn't stand. But I'm not making any submission on the merit because appeal is not before this honorable court. It is not registered yet.
There's any government side, any others?
And understand. And there is no bona fide mistake. It is a bona fide mistake of this the applicant lordship. They have intention. It is not unintentional. They are knowing of the record that the revision is not like even after this they have filed review against the order of the revision.
28. 24.
Delay not condoned, but 300 days delay is there by their own negligence.
My lord, please. So the submissions which I understood,
Given you time, it is in order column. I was not supposed to hear the matter because there are many matters there.
my lord,
Though I have heard and you've given you quite
my lord, please.
time.
I will not travel this one.
Hear about that.
Just few dates, my lord, which may be important. My lord,
Now see, dates and etc. will come important, but the question is that now only your question is that you are aggrieved by the order of inclusion, you as a party in this case.
my lord,
Though actually this was between the state and central government and the beneficiary.
that is my
That is your
grievance and the
grievance.
direction of payment against me.
And direction of the payment against you. But in that case, as you have submitted by so this, you have already preferred and reviewed that was earlier rejected. With a direction that you better option is to file an appeal. But in spite of that direction, you sit for 300 and more days, and then only you have come with an appeal after dismissal of your second review petition. So that is the case. So now delay, you are saying that your case covers under section 14 of the Limitation Act. That much only we have already heard you, that you have said the judgment you have already cited.
Just 2 points, my lord, and then I'll firstly, the law which my learned friend is supporting, that is not applicable in this case. Let me tell you why, my lord. Because my lord is aware, all judgments are passed on the basis of the facts of the particular case.
Okay, yes.
That constitutional bench judgment is not applicable in this case because the objection which was raised of maintainability was raised by the opposite party. Point 1. Point 2, my lord, in my matter, the liberty which was granted by the order of CRP, that is on 21/6/2024, that liberty was continued in the review order also, my lord. The review order of 10/3/2025, my lord, on that case, my lord, if my lord comes to this finding that after a decision has been passed by this honorable court, the review cannot be done in time with whatever is spent on review, it cannot be covered under section 14, my lord. That is, in my humble submission, will be bad law, my lord. Because a legal, once a law provides a remedy to me, I can exercise that remedy with good faith. I have done it. Because a particular point was not brought to the notice of the honorable revisionary court, that point was argued before the revisionary court. The review was filed on 19/7/2024. The decision came on 10/3/2025. Till such time, my lord, their order of the main common judgments review was any decision was not passed on that judgment. That judgment was only done on 13/6/2025. So till 13/6/2025, there is no prejudice been caused to him. Very important, my lord. Till 13/6/2025, there is no prejudice at all caused to him. Before that, I have filed my appeal. My appeal is on 28/4/2025. So till the date of filing my appeal, there is no grievance of him. There is no prejudice of him. So what good faith and everything he is arguing? Because in this case, if the loss or the prejudice will be caused to the institute, my lord, the Government of India Institute, is me, my lord. Now, my lord, very important, if 1 minute, my lord, I may, my lord, if I, my lord, one more submission was canvassed without showing any records to that. So that the submission is this, my lord, that the order of the common judgment is not in existence. The common judgment of 23/2024 is not in existence. And as on this date, the review order is existence. My learned friend should have on that case brought the review order to make the submission. He has not done it. Let me read that particular para, because my lord will appreciate what the learned district court has observed in that paragraph. It is not before that. If my lord wants, then I can bring it through an affidavit. But the observation is this, my lord. It is hereby made such and such. This instant order be read along with the original order. So what the court has done, the common judgment had not considered the interest part on 28. So by the review order, the review order is actually subsumed in the common judgment, not the other way around, my lord. It is not a case of merger that as on this date the common judgment is not there. If the common judgment is
Obviously, common judgment is there. It is only the
the
interest
part of a common judgment which was missing, it is a case of a reverse merger. It is not a merger case where the primary judgment has been merged in the review judgment. No. So firstly, my lord, no prejudice has been caused to him. So the entire argument of due diligence and everything doesn't stem anywhere. Second argument, my lord, the law which has been shown, that law is for a particular set of facts. That particular set of facts is not here. Thirdly, if this honorable court is not accepting my period lost in review, that is between 19/7/2024 to 10/3/2025, then my lord has to come to a position of law where an opinion expressed by a court cannot be reviewed. Otherwise, it will not be covered under section 14. Because an opinion was given by the learned coordinate bench of this honorable court, but the court has said you go for an appeal. But on the merit, we were challenging on review. My fourth submission is that the liberty which was granted to me in the decision of 21/6/2024, that continued on the date of on the review order also. That liberty of filing an appeal, that continued on the review order also. That liberty was not taken back. That is the reason I have filed that appeal, my lord. Thus, my submission is this, my lord. Specific submission is this. The liberty which is granted in the order of 21/6/2025 is extending on the date when this application and the appeal was filed. Thus, my delay of 334 days may be condoned and my appeal may be listed and for further hearing of the case. That is deep local.
Just on the liberty.
Because we have already
liberty-
submitted, my lord.
Liberty is given the disposal order of the CRP, my lord. So liberty to file appeal, not liberty to seek a review or delay, lengthen the delay. So liberty by the review order, there is no mention of the liberty there in the review order. So this is and about the facts of the case. In the case that I have cited, it is the opposite side that pointed out that it is not maintainable. Even then, the Honorable Supreme Court has held that this doesn't come under article under section 14. And in this case, my lord, this Honorable Court has pointed out that this was not maintainable. Even then, the time wasted seeking review. So it is not covered under section 14.
Deep local, my lord.
Same.
Lord is passing order. My lord is typing the order result. Blank.
May please, your lordship.
What is the delay here?
Lord, IA Civil 3356 is listed before this honorable court. And this was filed to condone the delay in filing the order 22 rule 9, that is the setting aside of the abatement. And my lord, during
What is your delay? Delay
delay is
1067 days.
yes, my lord.
Yes, sir. Do you want to submit here in objection?
No, I am preparing for respondent number 4.
Appearing for respondent number.
And copy notes are upon me.
Copy of the petition is not served on you.
I am sorry.
You are for the respondent number 4 and you are 1 and 2. 1 and 2. 3 you are not appearing or 3?
3, my lord, 3 has expired, my lord, during the pendency of this appeal. So
3 expired?
yes, 3 has expired. The IA 1844 is for, my lord, condoning the delay in filing the second appeal. During the pendency of the IA 1844, my lord, when the services
Three died.
services came back, my lord, we came to know that
Now what, you have not taken steps, I think, till date.
no, my lord, we have taken steps.
No, in IA 1844.
Yes, my lord, we have taken steps.
This
That-
is the first time it has come. I don't know whether you have taken steps.
That is why, my lord, these IA civil 3356 and 3357 and 3358. I have taken steps regarding, my lord,
your 1844 is of section 5, isn't it?
yes, my lord, that is for condoning the delay in filing the regular second appeal. Second appeal is yet to be, my lord, numbered, my lord.
Yes, it is
Yes.
yet to be numbered.
Yes.
No, I'm. Itu kode gitu. Kita. Oh, itu. Itu 3356. Itu 184. Itu 184. Three, 5, 7, 3.
Possibly notice may go.
Notice has to go. That's what I'm saying.
Yes.
Mhm.
But
Because
for
this is first time it has.
yes, for the first time, but my lord, as the learned counsels were appearing in the IA, they may I have provided them the copy. In respect to 12, my lord, I was supposed to take steps. I have taken steps, and my lord will kindly see the office note in the IA 1844, my lord. Kindly see the office note in IA 1844 that I have taken steps. Last of the office note, my lord. Second last of the office note. That I have taken steps upon 12, but there is no report as such. Second last of the office note in respect to respondent number 12.
You take steps. Very confusing. I don't know. They have appeared. The remaining you take steps. What for the IA 1844 was for?
1844 was for condoning the delay in filing the appeal, my lord. RSA.
But during the pendency of the 7 days delay to condone, they have filed this substitution petition
Because
respondent number 3 and 3
3 has expired. 3 has expired.
Service was not completed. So well, at this stage, my lord, notice may go to the respondent number 3 legal heirs of the respondent number.
What about the other respondents?
Other respondent, my lord, I am appearing for respondent number 4. My learned friend is appearing for respondent number 1 and 2. So for other
1, 2, and 4.
1 and 1 and I'm for 3.
You are for 3.
Yes, 4. 4.
4.
If my lord sees order dated 28/10, my lord, passed in IA 844, notice. If my lord sees the order dated my lord 14/6/2023 in IA 1844, my lord.
Issue notice. Issue notice. 58 or IA 3356. Hard Mr. NBPC done for the petition. An applicant Mr. You are Mr.
I'm H dash for respondent number 4.
It's just for respondent number 4 and you are for 1 and MH Taluta for 1. You should notice to the other rules with symmetry recording. Quickly restrict after 4 is very confusing. Take steps. Also, the petitioner is directed to furnish the extra copies of the memo of the extra copies of the petition to the respondents. Number 1.
39.
Right. May it please your lordship. The applicant has filed this IA for a direction to the opposite party to deposit 50% of the awarded amount, lordship. The applicants, lordship, the applicants are the claimants and the wife and minor child of the deceased.
Any objection?
Lordship,
This is what-
we haven't taken, where is the provision for a claimant to file a petition to direct us to deposit 50%? We have not taken any stay in this case. There is no
Oh,
policy.
you have not taken any.
No, then
Lordship-
can they file a petition? Where is the, they let them show any provision? Then only, there is no
Lordship,
provision.
what is the problem here, lordship? And this order was passed on 30 of November 2022, lordship. Thereafter, they have filed first of all, they have filed one IA for delay condonation, lordship, which was subsequently allowed, lordship. Thereafter, they have preferred this appeal, preferred the appeal against that judgment and award, lordship. So what is the problem now, lordship? Trial court record has received here, lordship. So execution proceeding cannot be done there, lordship.
Hearing can be done, Lordship. LCR is received.
Lordship,
fix a date
it will
for
take
hearing.
much of time, lordship. With any by executing any bond, lordship, 50% may be deposited in the before the registry of this honorable court, lordship.
Any supplementary case record is maintained by the court,
Lordship,
court of MSCT.
lordship,
In that case, you can file a petition.
lordship, we
Because
have
there is no stay order at all.
lordship, no stay order at all, lordship. But trial court record is here, lordship. Trial court record, no scan copy,
See,
lordship.
they have agreed or to that award or against that award, judgment and award, they have come before
Lordship,
petition.
lordship,
For some reasons, I don't know what were the grounds.
lordship.
Now the question is, how can I direct them if your appeal is allowed and you are supposed not to, you're not supposed to entitle for any benefit or the award.
Lordship,
In that case, what will be the
lordship, generally what had happened, lordship,
make any direction here at present? Go for hearing, speedy hearing.
Yes, Lordship will fix a date, any date, except for February 22, 27, Lordship. Any date, I am ready to do the hearing. Because LCR has come, can be finally disposed of. And why they want 50%, they can take 100% if we lose the.
lordship, that will suffice. Lordship, if hearing is done in the second week of February, lordship, I have also no problem, lordship. Because the family is suffering, lordship. Two minor children are suffering, lordship.
Your award was in which year?
Lordship, 2022 November, lordship.
No, I can understand.
The person who died was only 34 years of age, lordship. And his wife and minor children are suffering, lordship.
Yes, I can understand. But I cannot direct them to pay because they are not filing any petition for
Your technical problem has arisen, lordship, because the record has come here, lordship.
record.
That
has
is the
come,
technical problem,
But
lordship.
initially, if they could have paid for an state, definitely an order could have been passed.
Lordship,
regarding
they have
the
not
payment.
paid for state,
But they
lordship.
have not paid for. They already the record is there. So
Lordship.
at that stage, you could have come with a petition in that case, or as they have not paid for any stay, one execution petition could have been filed before the learned MSCT court.
Yes,
Lord,
because
they-
admission was
could
done
have been
only
done.
in
But
20.
at this stage, may not be possible.
Lordship, then
But still, you can try or you can file a petition before the learned member MSCT. If because stay is not here.
Lordship.
So in that context, you can approach.
Lordship, then
If they have already prepared any supplementary case record, in that case, it may help.
lordship, then this may be disposed of, lordship.
Yes, it will be
Disposed of. An observation may be made that if the applicants want to approach the learned
No.
trial court, lordship,
Where is
that
the
will suffice, lordship.
That's why
I'm just
I
probably
started with where is the
you, that
provision?
cannot be. Rubbish. Administrative report will be done. Petitioner, applicant, respondent. of the claimant, the respondent of the applicant in MSC 654 of the. This is an application praying for a direction to the insurance company of the appellant to deposit 50% of the awarded amount as the awarded amount dated 30 and as per in percent to judgment and judgment dated 30/11/2022 in MSC case number 124 public 2015. It is submitted by Mr. Bordolo due to delay in disbursing the award. The entire family of the claimant is suffering, who is now living with 2 minor children. MS Mojum, the learned counsel for the respondent, submitted a raised objection and submitted that there is no such provision to directly direct the insurance company to deposit 50% of the awarded amount, as they have not paid for any stay of the judgment and award passed by the learned advice. It is seen that there is no such order of stay passed by this court, but accordingly, at present the interlocutory petition cannot be allowed, directing the respondent insurance company to deposit 50% of the awarded. However, considering the urgency of this case and submission made by learned counsel for the applicant claimant, the hearing in connected MSC appeal of 654/2024 may be heard and decided. May be heard and decided. May be heard and decided to the extent of the with the above observation, the present highest instance or MSC appeal or heard MS RD Mujum learned counsel for the appellant and also Mr. P. Bordole for the respondent in view of order passed in IA Civil 4016 of 2025 that the matter be listed. When you see
19 February, Your Lordship.
Lordship, 19 February, I won't be coming, though I'll be in Guwahati, I won't be coming. Before
17 February.
17 February is when, and endeavor shall be made to hear and discuss.
And in the meantime, Lordship, registry will write a note about respondent number 5. They have given an office note of respondent number 4 being served. Respondent number 5, they have to give the service
report.
Yeah, office note, Lordship, office note they have not mentioned. Lordship will peruse office note dated 12/12/25. In that, they have mentioned that for respondent number 4, process server report has come served as flag A. But for 5, they have not given any report.
Whether the registry they were directed to report on the service of notice on respondent number 5 on the next.
Highly obliged.
Obliged, Your Lordship.
May I please, Your Lordship? We have filed the IA for allowing us to withdraw the deposited amount, Lordship.
Do you have any objection?
Yes, my lord, we are going to file a objection then in this regard, my lord.
Your
The appeal
appeal is on only on quantum or any other aspect?
My lord, it is actually a fraud case, my lord. We have already
Fraud case?
explained in
In that case,
yes, my lord.
Money is, Lordship, may I?
Although
money
we
is
have
lying-
deposited one, but they are
Put-
not allowed to.
It has been deposited in the year 2017, Lordship. 31/1/2017, 9 years, Lordship.
2017,
That's why it has not been, no notice has been issued to us, Lordship. Neither our earlier lawyer has informed us. Just on few days back when we have inquired about, then only came to know about this. Money has been deposited. Normally, registry issues notice on once deposit. And nowadays, after this Gohar Mohammed judgment, Lordship,
There is
in
one
website.
aspect. Notice, most probably they have not issued notice by the registry as there is no order of any
No,
disbursement.
after the government judgment, Lordship, normally in websites, we have maintained all the deposits day by day, even in the trial courts also, in the high court
Okay,
also.
that is the procedure.
But in this case, Lordship, this amount has not been reflected in the registry also, this website also.
Because order of 2017 and
Most probably, at the time, that process was not there, Lordship. So we are suffering from,
do one thing, if you have any objection.
we are
my
giving
file of
indemnity bond,
objection,
Lordship.
Isn't it?
No, my lord, we have already explained in
No, it's okay. You are going to file objection in the I, present I also.
my lord on main appeal, my lord.
No, it is their appeal, Lordship.
In their IA, my lord.
No. Appeal is okay.
Huh.
Appeal you have filed, you have taken
Huh.
ground. I'm not on that. This petition interlocutory application they have filed for this withdrawing this money or for release.
They
In
cannot
that
be.
case, you have objection.
Yes, my lord.
So you are going to file in written
File objection,
objection.
my lord.
Now, see, filing written objection, hearing on that point, and the entire matter,
Yes.
it will more or less the same.
Moreover, Lordship, may I draw your kind attention, last order says, Lordship, notice to the number 5. In 9 years, they have not taken steps on notice, Lordship. In 23, one order was passed for steps of notice.
Right.
Because we have to file cross objection also, Lordship. Once cases come for hearing, then within 30 days, we have the right to file the cross objection also.
According to
Notice on 5, respond number 5. It was in 23, last order was, case was taken up in the year 2023, Lordship. If they are not interested, let him start up.
now, one thing I don't know. Now here it is. This is in the office note dated 19/1/2026. Stay headed according to
Yes, my
server so and so. Unserved notice of the same respondent issued through registered post, with AD has been received back with a postal remark refused.
So they have to take fresh steps either by postal paper advertisement or whatever the way.
If it is supposed refused,
also is
then
It is 9 years.
it is served. Who is 5 in fact? Who is 5?
Owner.
Five is
Owner
the
of the
owner.
tractor.
Yeah, as per you, owner is
Necessary party, my lord. Yes.
in that case, so it is refused. Refused means it can be deemed to be served otherwise, because refusal is others. So otherwise also, yes, the service report is yet to be received. So you take want to take steps, fresh steps to respond number 5. Can be.
Yes.
But now see, there cannot be any delay
We have to
further
collect
in
proper
doing
address,
that
my
there this IA because of it is already 8 years left. The petition for praying for withdrawal of the money. So it has already been delayed. So only by the next date you file your objection, written objection, and by that time, if the service notice of the respondent number 5 also returns, then matter may be heard finally also. Right. So I had to take Mr. S.K. Koto, learned counsel for the applicant, respondent, applicant claimant. Ms. Kalsh. For the respondent, the present interlocutory application is filed for paying a deduction to the registry for release of the deposit, and 50% of the deposit, 50% of the awarded amount which has already been deposited, deposited by the respondent in pursuant to order dated 4/01/2017, passed by this court in IA Civil 1799. MS Al Sharma, the learned counsel for the respondent, appeals of and submitted that they need some time to file the return. Prayer allowed with a direction to the respondent by their on before the next date of listing without further delay.
A date may kindly fix.
Next date, yes. When?
In the month of last week of February, my lord.
Maybe on 25, 6, 7, whatever, February.
25 oh sorry 25
Obliged.
Obliged to আৰু আপুনি থাৰ্ড চেঞ্জ কৰি দিব নহয় MEC RMS L Sharma, learned counsel for the Mr. S.K. Putra, the learned counsel, appearing for the response. And from the office note, it is seen that the service is still awaited for the response number 5. Accordingly, Mr. And the applicant is hereby directed to take steps upon the response number 5 within 3 of the 4 days. Matter may be listed along with the I on 25.
I beg your lordship's indulgence and to peruse the IA Civil 57 of 2026. So in this case, I'm appearing for the, actually initially, originally we are the claimant, now it is the applicant respondent. It is for allowing the claimant to collect the 50% that has been deposited by the insurance company in the office of the registry.
Yes, do you have any objection?
We'll file our objection, Lordship, because it is a pay and recovery. Okay. It is a pay and recovery case when the driver did not have any valid license. So with the absence of owner till now, we will file our objection.
So may I please your lordship, I find it is quite irrational because my owner may kindly find out what this just IA 2629/2025. There's a precondition that has been given that since their order has been stayed and condition is that they have to make the payment. I do not find any reasoning over there that why the objection is lied there because already condition has been given.
Order given, Lordship, with
No,
the
no, but is this is technical, my owner may kindly find out IA 2829 of 2025 is ordered at 29/8/25. Why this I can't understand, it quite sounds very absurd. My client is I am a crippled person and the other insurance is a big institution who is saying that they are going to file on what basis? Because the basis that has been given is that it will be stayed only on the condition that they will have to be paid the 50% on the deposit on that free.
We have deposited.
Deposit is nothing to do because this is not a bail or bond something. We are not depositing it because it is a security. It is deposited is very implied and rational. Then I do not understand that fallacy. What it means to say that again objection. It will. Your lordship knows very well that why it is given there. Only thing is the operation portion was not there and we have filed an IA so that it may be given to. But it doesn't mean objection every time we'll have to face the litmus paper every time for any come because for any ground they will come and they will stay that and on the very stay it is given there. I do not find why it sounds not, but it doesn't sound
The
good.
question is that obviously there's a order of payment of 50% of the amount which they have already paid and deposited in the this line before the release. But the question of disbursement or the release is not there.
So
now their question is that their entire appeal is not on the quantum. If it is not appeal on quantum, suppose the release is all right. But their entire appeal is based on pay and recovery, which they have agreed. Now the question is that if suppose the release order is there, I don't know. As a court, we don't have any objection, but as from their side, they may have some objection. Do one thing. Our thing is
LCR has not.
The LCR is not important because LCR is important at the time of hearing.
I'm not on that. LCR, I'm
because on that very day, they should have said, may I please, your lordship, I'm so sorry because my client is so hospitalized and for that reason I'm saying that it is very clear. Though the operation is that why they have deposited there. What's the meaning of deposit? Is it like a bond that they will run away with a small institution? It is implied, it's very clear enough. We do not go for the intricacies and tangle ourselves in some words and giving some putting some with all due honesty, it's only belied and decried the basic objective and procedures of the court and the act of the judgment. They are giving objection. I can't understand why objection is required because it is already given there. My client, why? May I please, lordship? Only thing is that if my lordship knows very well, my lordship has passed some numbers of orders like this. This is not, but why this is given? Is very clear. It's very explicit. Though it is not, it is given only for the survival of the client. Yes, survival of the client. It is a case of MSD case. This is a case where a person has died. That objection is violating these things. Objection, amples of scopes is given there. They can go for it. Even in this case, interestingly, we have also filed another case where for the enhancement and notices have been served to them. But I don't understand that it is just like screwing this person with another knife and making the life horrible. I do not find this submission at all have any this one rational or anything things. I don't find. So my
Yes, but
my
if
lordship
they
is
have
that
also
what
filed
is
an
this
appeal,
argument?
there must be something
No,
very
this
wrong
is
with
for
the
this is for
judgment.
enhancement.
If they have
But
also
wrong and
filed-
right is different thing. But thing is that now it is a question of my survival. Now it is a question of my fundamental right. Now fundamental right of life is not given. Tomorrow, if I die, we'll take this burden. So this has been given. The court has been kind enough towards me. Court has been so good enough to every claimant, and for that purpose it is given. I do not find anything. It sounds really ridiculous on their part.
You are going to argue this matter, or you need some time, because
No, I'll
he has
file-
submitted rightly, because the order is of.
It's very obvious things are there.
File my objection,
It is-
Lordship. Lordship, if he won't allow, I'll say it, Lordship.
No, you say, you can say.
Lordship, what I have submitted is I'll file my objection and that the hearing will be done. Otherwise, I have all these judgments, Lordship, which I'll show that we are not wrong. Today is not possible. I understand, Lordship. So we'll file an objection and Lordship will give us some time to file an objection, maybe 3 weeks time. And we'll file an
Please, but I don't find it. I do not find any anything. I do not. It is not about the judgment. It's not about the law. Here, the main fundamental question is that whether I will survive or not.
submit, then
If
what
I'm
is
not
the
given the
use of
survival
it?
things,
Lordship, the judgment was passed on 2012, 2024. This is 26 now. What are they doing? HCM now they want that I should not take 3 weeks time, but they have been sitting
it is
for
not, it
more
is
than
not
1
about
year
pointing what I have
without
done. It is not a stereotype case.
I have a right. Fundamental right is only of the claimant, not of other parties. I also have a right to file my objection, Lordship. And if that is denied, fine, I'll do the hearing. No issue with me.
It is
Let's raise
simply
the-
for the sake of argument. Now the question here is the survival of the claimant. That thing has been given for the survival of the claimant. Lots of hearing can be done regarding the hearing case, but I don't find anything very rational on part of the instrument. Only for the sake of argument. If argument is made, then it is very pathetic on part of the judiciary. Other, I will say about my client. Only for the sake of argument, argument shouldn't be done.
Done it on the second payment and also starting June and constantly for the respondent. This is an application filed by the applicant claimant for withdrawal of 50% of the deposited, 50% of the awarded amount, which has already been deposited by the respondent insurance company in person to order dated 29/8/2000. However, MS Mujub counsel for the respondent appellant submitted that she did some time to file her objections, as the appeal has been filed on the ground on agreed to the order of judgment and award passed by the learned member MSC, wherein the order of pay and recovery was passed. And your this valid driving license was not there, or what was the ground?
That was the ground.
There was
That is why pay and recovery was accepted.
Having no valid license by the no valid driving license by the driver of the ticket. In that context, Mr. Sharma, Ms. Kusami also submitted that the fundamental right of the claimant to withdraw the money as which has already been deposited by the insurance company, as the party is also suffering due to it is not a dead case, no?
It's an injury case. It's far more grievous.
Due to injuries, but out of death, motor vehicle.
Your Lordship, I can
considering this counsel for the respondent but in 1 week, can you?
No, Lordship, no.
Your Lordship, I just want to point
because
difference.
Lordship, we have some holidays and
There is a partial income non-compliance because all the amount hasn't been paid. Only they haven't deposited the interest portion, which amounts to a big amount. They have only partially complied with the things. They have only given what's the amount devoid of this interest portion haven't been deposited. But what has been asked by the deposited half of the is their fault. They have non-compliance on their part. One thing is that they have not complied with. Second thing is that they again are giving points.
Is today the hearing taking place, or it will be?
There's a non-compliance. It's partially it has been paid.
Submit that on that.
Partial payment, I can say about the quantum. This is partially played.
Then when will be able to? Because
2 weeks, Lordship. I asked for 3 weeks,
Fix the
but
date.
Lordship, 2 weeks can be given. Let it be on 9th, the week starting from 9th if it is possible. Otherwise, as a Lordship.
9th of February,
Yes, because 2 weeks
2
will be
weeks
there.
started.
Yes, Lordship.
10 month দিব।
দ্বিতীয় দিব
10
পাৰে।
10
Fine, Lordship.
And what about the main case? We have not received the query.
No, LCR reminder will go, Lordship.
To take it out, reminder be issued for the TCR distribute. And what about the other respondents?
We have taken steps, Lordship. So maybe in the meantime they will appear or something. 2 and 3 we have taken.
Also awaited for the list. Yes, I mean, hurry, I have
I leave
meeting again, in fact. Why not? See, one matter list for this. Koile teacher, then I'm side of the good kitia, correction for you, kitia. Hearing of no on county. Here's it. What are some like you hearing?
May it please your lordship. Lordship.
How many days delay?
100 days, lordship.
Issue notice. By issuing notice, the first time it has come.
Deeply obliged, lordship.
Okay, issue notice to the respondent number 1, 2, and 3 through speed post. Nowadays, speed post is there, and also through usual process.
Deeply obliged.
Otherwise, 100 days delays, it's okay, but let them appear and we'll file it. Your good name?
D. Datta, lordship.
MS D. Datta, na? MS D. Datta. Part MS D. Datta. We're listing it after 3 weeks. You take steps.
Deeply obliged. Lordship, may kindly fix a date.
Date is may not be possible. Let the service be completed.
Obliged, lordship.
Multiple level people.
Documental is 44.
Hearing no hearing will be taken up. I'm sorry. Hearing I cannot take it.
No, your lordship. It is.
What about this here? It is in order column. Why it is in order column? Why it is in order column?
What have been listed for
Admission
admission column? Wrongly listed
Admission
in order
column.
column.
Because on the last occasion on yesterday, it was fixed for admission hearing.
Oh, then?
Then wrongly it has been listed. So any date, your lordship.
But I'm not in a position to hear the matter today. Because I have a meeting again. So lots of matter corrections are also
Maybe fixed on 27, lordship.
On 27th, if it is possible, your lordship.
Admission.
27 may not be possible. Let it be on 28.
28th, I may not be available, your lordship. So on 29th,
It may take some time also, lordship. So better to fix hearing.
No, in hearing day you need, na?
Yes. 29.
29th, if it is possible.
29. 29 is a
Yes,
hearing
your
day.
lordship.
We can fix it.
Admission column, matter maybe.
You will fixing it admission column?
Yes.
We'll try
Yes,
to hear the matter and disposal. Today is not
No,
possible.
it is not.
Time.
It may take also some time also, na?
Yes, sir.
Okay, heard Mr. R. Ali, the learned counsel for the petitioner, and also heard Mr. A. Biswas, the learned counsel for the respondent. It is submitted by learned counsel for both the parties that has been wrongly listed in the order columns, not to have been listed in the admission. In view of this, let the matter be listed in 29/1/2025 in the admission. Procedural routine.
Highly obliged.
May it please your lordship. Lordship, some more time may be granted to take step upon the
taken
rest,
steps.
lordship.
Otherwise, your appeal is admitted, na?
Lordship.
Your statutory deposit order of payment of statutory deposit also there.
Lordship,
At the time of filing your appeal, you have not deposited the statutory deposit.
Your lordship allowed us, had order dated 15/12, lordship.
Then
1 week time may be granted.
you are MS?
F in does.
F in
It
dust.
does.
Hard MS F in dust. appellant. Is submitted by her that inadvertently the steps could not be taken against the respondent. In the same time, the statutory deposit of 25,000 also could not be made before the could not be deposited before the registry. Considering the submission made by her, the appellant is thereby directed to make the deposit of statutory deposit of 25,000 on or before the next date of listing. And in the same time, he also asked to take steps on all the respondents through speed post and initial process. Let the matter be accordingly listed. To make your statutory deposit,
Lordship.
it is necessary.
Obliged.
46.
Overrides. So why?
May I please?
Yes, Mr.
My lord, this IA has been filed, my lord, as per order dated, my lord, 5/3/2025. Lordship, may I come to page 19 of my IA mail.
5/3/25.
Yes, my lord, 5/3/25.
Page 19.
19, my lord. Service is completed, LCR received. Leaves the matter for hearing in its usual course. Liberty is given to the parties to file application before filing for early hearing of the matter. So this application has been filed for early hearing of the RSA matter. This is my prayer.
Your RSA is of 2024.
My lord, since my lord, it is concurrent finding, my lord, and the my lord, RSA has been
Okay, I
admitted.
can understand hearing
My lord,
for
I have
every
some-
case is essential, but it is not so old.
My lord, so it is admitted fact, my lord, but it is not. But my lord, any date, my lord, lordship, my lord, he said
Yes,
date, my
in that case, we want to submit anything.
lord. They have no objection, my lord. His senior, my lord, we discussed the matter, my lord. Any date. There is some, it is concurrent findings, my lord, and the appeal has been admitted on the first day, my lord. It is page 13, my lord.
You are Mr.
M. Alam.
M. Alam, appearing on behalf of Mr. Hussain. MP Hussain. This interlocutory application has been filed under section 151 CPC. Praying for early hearing of connected RSA 148 of report in person order dated 5/3 or
Yes, madam. Page 19, madam.
5/3 2020.
Page 19. 5/3.
5/3/2020. Mr. Alam, appearing on behalf of Mr. Hussain, also stated that he has no if the matter is posted for early. In view of this, the present interlocutory application has been filed. Is disposed of, and with a direction to registry to raise the matter accordingly for hearing. And hearing and endeavor shall be made to hear the matter at the possible earliest. With the above observation, the eyes test.
Only
Yes.
lordship, my lord, may fix the date, my lord, in the month of February, last week.
Card, Mr. And click. And also pursuant. This year has already been received. In pursuant to order passed in IAC 3/3/2025. The matter be listed and the matter be listed for hearing 27/2/2025, and endeavor shall be made to hear the matter.
It is fixed on 27th February, my lord.
27.
It is, my lord, motion day, my lord, in any hearing date, my lord. It is.
26, sorry, 26.
Plus.
Need please, your
Yes,
lordship, madam.
what is 47?
That's in this matter, my lords, I've gone through the records, my lords. The written objection filed by them, my lords, is not on record. Let it be on record, my lords. My lords will pick any date.
You have already filed your written objection.
Yes, Lord.
It's not on record.
It is not in the part of record, maybe part of record, Lord.
Okay, it is not only part of the record. When otherwise you have received a copy.
Yes, ma'am.
Let it be on record, my Lord, and be fixed in the first week
First week of
February.
February, ma'am.
What is the IA for? In fact, I is for your I is for what? 39 rule 1.
Yes.
Objection diabolico. Affidavit. It's not reflected in the office note also. But you have already received.
On 19th January, we have filed.
19th of January.
January.
Okay, office note. Oh. Third, Mr.
Going to J. Mediman on behalf of Mr. P.K. Dekar.
What?
I, ma'am.
You are Mr. J. Medi.
Yes, ma'am. On behalf of Mr. P.K. Dekar.
On behalf of Mr. P.K. Dekar, the learned counsel for the applicant. You are for the applicant and appellant also, na?
Yes, ma'am.
And also heard you are Mr.
S.A. Borbuy on behalf of S. Das.
S.A. Borbuy, appearing on behalf of Mr. S. Das for the respondent. It is submitted by Mr. Borbuy that they have already filed their written objection, but which is not available or tagged with the case record. Every record. Perusal of the office note also, it is seen that regarding the filing of the written objection is not mentioned in the office note dated 15/11/2025. However, it is submitted by Mr. Borbuy that they have filed their written objection on 19/1/2020. But surprisingly, here in the office note in 20/01/2026, no objection has been received by this section till date. You have filed on 19/1.
Yes, 19 we have filed, Lordship. Lordship, we have also submitted.
Serve the copy. Yes, I can understand. Yeah, all right, and office note to video. 11 from the office note dated 20/01/2026. It's seen that the no objection is not received by the section. However, it is submitted by Mr. Borbuy and they have submitted their written objection on 19/1/2026, and copy is already served to the other side. In that context, registry is hereby directed to tag the objection which has already been filed by the respondent side, and order directed to tag the same. The matter will be accordingly listed on
First week of February.
first week of February.
I'll just fix a date, ma'am.
Date fixing a date is possible, not possible in each and every case. First week of commencing the second day, February month to Ketiapa commence first week. 2 commencing from the 2nd of February. First week of February commencing from doing together. Okay.
Deeply
obliged, ma'am.
Okay. May I please, your Lordship?
So there are several I's.
Yes, Lordship. I will take very little time, Lordship, to point out. Actually, this IA, Lordship, the main appeal, Lordship, the RSA, these IAs are arising from RSA 200 of 17, Lordship. The main appeal was, Lordship, dismissed for default, Lordship, way back in the year of 2019. RSA was dismissed for default. Subsequently, Lordship, within the prescribed period of limitation, we filed an application for restoration of the appeal. While the restoration was pending, Lordship, the respondents, 2 respondents were there. I am the sole appellant. Both of the respondents, husband and wife, Lordship, the decree holders, they expired. One expired in the year of 2019 after filing of the restoration application. Notice were issued, and in office note also contains that one of the respondent had received, but the other one expired. But it was not in our knowledge. 2023 lordship, the other respondent, his wife, she expired, and accordingly the legal heirs lordship, they took steps for substituting themselves before the executing court. Then suddenly, few months back, we received the notice from the executing court lordship. If
Now, sorry, we don't have time.
lordship, one is for condonation. The first one lordship is 114. That is for condonation because both of the respondents have already expired lordship. So we had to substitute them, and already the restoration proceeding lordship has abated lordship.
So even if suppose we issue notice, to whom we are going to issue notice?
The legal heirs, we have made them party in the for substitution. Yes, in the condonation one, lordship.
Both these are the legal heirs of the
Yes, yes,
respondent 1 and 2.
yes. Only while we received the summons from the executing court, we came to know about their names, and I was residing outside the Assam lordship. I've mentioned in the paragraphs of my condonation application. Very briefly, I have made my pleadings in that respect.
I 111 order. 111 of 2010. Part Mr.
PDAS.
PDAS still uncountable for the this is an application second seeking condonation of delay in how many days delay you have to
Lordship, for the respondent number 1, 2,180 days, and respondent number 2, 948 days, Lord. It's a very long time, Lord.
a condonation or delay in preparing the substitution petition for the deceased respondent number 1 for how many days?
One is for 2180 days.
180 days and
another is 941 8 days.
948 days.
I mentioned the names in the prayer, Lordship, the deceased respondents.
This is respondent number 1 and accordingly, we further submitted that these are the only respondents who contested the case, but after their expired, the legal heirs of both the respondent number 1 and this is respondent number 1 is required, and the present application has been filed for substitution of the legal heirs of the deceased respondents in restoration proceeding, IA number 3417/19, arising out of RSA number 200 of issue.
Okay. I have also filed one accompanying application there. That is I. So, Lordship, will take 2 minutes only, Lordship, because I don't want to trouble this honorable court. Lordship, IA number 114. Now, Lordship, since the appeal has been dismissed for default, the only pending list before this honorable court is the restoration proceedings. Now, while they have taken steps, Lordship, for substituting them, they are aggressively continuing with the execution proceedings. If in Lordship, if the execution proceedings gets concluded, all our restoration application.
It's time to clear. I don't have time.
Lordship, till then, at least a stay